Lordship, I beg to mention an urgent 438 application for listing. That's because the wife of the petitioner, my lord, is undergoing a surgery as we speak right now in NP hospital. And allegations are level under 420, 406, and 376, my lord. Tomorrow, my lord. Deeply obliged, my lord.
With the Lordship, my lord, with the consent of the other side, my lord, I beg to mention in your 34. Next week, my lord, which day are you on 13, my lord, will be taken.
Item 4 at the request of 34.
Yes, 34. my lord.
44. Sorry. 34. So this was heard.
Yes,
Have you
yes,
taken
sir.
consent of the counsel for the petitioner?
I have taken consent, my lord. Next week, my lord, there will be some difficulties, my lord. On 6th or 13th, my lord. 6th or 13th.
We can't keep on changing dates and fixing dates like this. Our calendars are full.
Yes, yes, and for convenience of the honorable person.
Let it be on 8th.
If some difficulties will have.
Why don't you give your calendar, mark the dates, and then tell us that these are the dates available as per your calendar? We'll fix the matter.
Difficulties, my lord.
What is this?
Except able any other day.
Today is difficult. 8th is difficult. 6.
Obliged.
Let it be on 6. Yes, item 1 minute. Item 34 at the request of Mr. M.J. Kadir, General Counsel for the respondent. Matter is adjourned till 6. It is submitted that counsel as a consent of the counsel for the petitioner, MSMDV, B Devi has also been obtained. Yes.
For listing, order matter.
Listing order matters.
Yes.
List in July?
Stable.
July? No. Orders for what? For what? Orders for what? What matter?
One is the bail matter for high criminal offense.
IA criminal. For?
One is the.
No, IA criminal for what? In a criminal appeal.
Yes.
Okay. Let it be in the week beginning from 19th, any date you want to take. 20, 21. 21.
Please, Your Lordship, with due consent, I beg to mention item number 18, Your Lordship.
18.
Yes, Your Lordship.
Yes.
Lordship, Mr. D. Chakraborty appearing in this case is unwell today, Your Lordship. So it will for weeks time.
2013 matter.
Yes, Your Lordship.
You be available. We'll see.
Lordship,
You-
we taken consent, Your Lordship.
No, consent is okay, but then this is 2013 matter.
Lordship, possible for the day, Your Lordship.
You be available.
Yes, Your Lordship.
When the matter is called up, you be available. We'll see what can be done.
Lordship, I have another prayer. Item number 29, Your Lordship, I'm appearing on behalf of Mr. M.R. Devi, Your Lordship. Lordship, there is some personal.
And why is this matter listed here? Is it what part heard? This item 18
Yes, Your Lordship, I have heard this.
is part heard matter.
Yes.
Okay. Yes. Which matter next?
Lordship, item number 29, I'm appearing on behalf of MS MR Devi, Your Lordship.
29.
Yes, Your Lordship.
At the request of MS so-and-so Learned Counsel for the petitioner, appearing on behalf of MS MRDB, matter stands adjourned for 1 week. Adjourn will be listed after 1 week.
Interim order.
Interim order, if any, will continue till the next date of listing, list on 23rd June. Not tomorrow, next week. Next week. Why is it not listed? Today you have filed, you want it tomorrow, day after, it will come on its own time. When was he arrested? 2 May. What date is today? What were you doing? No, he was arrested on 2nd May. You choose to file the bail on 1st June, and you want it tomorrow.
We approached Lord Lordship, they rejected that.
Say that. So when did you file it? Today. It will come up next week on its own. You don't have to make a mention.
Monday, Lordship.
It will come up on its own. Just follow up and ensure that there are no defects.
Lordship.
It may possibly be listed on Monday itself, subject to there being no defects.
Wait, please, Your Lordship. I'm praying for listing of an AB on tomorrow, Lordship.
Why?
It is filed on Tuesday, Your Lordship.
No, not tomorrow, Monday. Why? What is the urgency? Why did you file it Tuesday?
Lordship, police is behind me, Lordship.
Kiman as a guide. All right, tomorrow.
Lordship, I beg to mention item number 19.
19. Yes,
Lordship, I am appearing for this weekend. Lordship, please out of this.
you wait until the matter is called up. You wait until the matter is called up.
I wait for mention for listing of item, listing of WPC number 6723, 2022. Lastly, it was listed on 22/2023.
Is it a partner matter?
No, it was on motion matter.
You are making a mention before wrong bench. I am taking criminal matters. You mention it before the appropriate bench.
4 weeks time was.
You mention it before appropriate bench.
WPC.
Logic. I beg to mention item number 32 bail hearing for withdrawal. This is AB matter, anticipated bail,
32
32 bail hearing.
1784.
Yes,
Yes, madam.
Sorry, also not received.
It is, on submissions of Mr.
SK Das.
S.K. Das, learned counsel for the petitioner. Who submits that he seeks to withdraw the anticipatory bail petition. He's been arrested.
No,
Then why do you want to withdraw?
client expected up to the case.
It is submitted that petitioner does not wish to press the anticipatory bail petition. Accordingly, AB petition 1784 of 2023 stands dismissed on withdrawal. MS SH Bora Leonard APP appears for the state. Yes.
Supplementary list for withdrawal item 31.
Mr. M.K. Bora, learned counsel for the petitioner, submits that on instructions that the bail petition preferred by the petitioner. Petitioner seeks to withdraw. He does not want to press the bail petition file. Accordingly, BA 1823 of 2023 stands dismissed on withdrawal. MS SH Bora, learned APP, appears for the petitioner. Case diary received, be returned back.
Not received.
If received.
Daily list for motion via item 1.
Let's go 13 application minute. The listed on 13/5, 20 days in custody. That will find a hard case clearly. The husband will be informed commit suicide mirror. You have to see the law of that. Please clearly. Mary.
Who's filing? I think we had dealt with another bail petition.
That order I have. You have to protect the petitioner in respect of Guru Kanta.
No control. So let us call for the CD then.
My lord,
Let us call for the CD.
I will inform that CD is in the PP office of the PPI.
Very fine.
I don't know, Lordship.
I will.
You may have information and APP does not have.
Next week, Lordship.
Now, next week, we'll take it up next week. Heard Mr. P. Hazarika, learned counsel for the petitioner. MS SH Bora, learned APP for the state. This heavy petition is filed with the petitioner as he was arrested on so and so date in connection with the Puria Police Station case number 81 of 2023 under section 306/34 IPC. Let CDB call for along with PM report. List again on. List again on.
Lordship, it is available in the case rate only.
7.
Lordship.
Seven.
7. It is submitted. Not necessary, you verify. If it is not available, we'll see.
For motion item 2,
Ma'am, please. This is second time bail application matter. Earlier it was rejected by your. And madam, he is given the new ground of civil commitment page. Page my lord. Paragraph 6 and 7. The allegation under section 10 of the code. The informant and it was are in relationship in class 2 years. And after and then transported by the Japan murder petition. In that allegation murder under section 376 is not affected murder. So they are in between them murder from last since 2 years murder and the extortion 384 murder. So not in the Japan murder and 313 murder related 313 murder. It was the page 12 matter particular. Second line. Page 12 particular matter, second line matter.
Yes, madam.
Otherwise, similarly consenting party lordship, the first treaty is concerned lordship. With the case study element 164 in the.
Heard Mr. So-and-so, Leonard Counsel and Ms. So-and-so. All for CB along with medical report and 164 statement. Interim will consider upon verifying,
Lordship.
upon
Actually, give
going
us
to
a
the
short
CB.
date for this.
We'll give you a short date. Matter be listed again on 19th.
Thank you.
19th. Interim to be considered. Prayer for interim to be considered upon perusal of the city if required.
4,
May I please, Lord?
Yes.
Lordship, 438 petition lordship, and that there is the land dispute between the parties lordship. And in this regard, the petitioner filed a 145 CRPC petition before the concerned deputy commissioner Counsel Amilo. And subsequently, lordship, the land is handed over to the petitioner. And in this regard, lordship, earlier 2021, the claimant petitioner number 1 laws and FIR before the and subsequently, and this case is stated under section 145 and 146. And now, lordship, the page number 12, FIR, laws against us. You'll find the page number 12. FIR against us.
Page number.
11%, page number 13.
Please read. Yes.
Now, with you, sir, I beg to state that on last 28/2/2023, the above land accused person came to the Okwamari shore with a petition constructing a house, and they asked to remove their houses in the Okwamari shore. And the accused person threatening to us that if they do not do so and they remove our houses, otherwise they will be set fire of our houses, and also they threaten to kill us by life.
Yeah, you read the vernacular, this translation is not correct.
Page number
Read
number 15 of it.
it.
অনুমানপূর্বক বিনীত নিবেদন এই যে যোৱা 28/2/2023 তাৰিখে উপযুক্ত পদবীয়াজনে ভকুৱাবাৰী চৰত ঘৰ বনাবলৈ আহে আৰু লগতে আমাৰ ভকুৱাবাৰী চৰত থকা ঘৰ ভাঙি লৈ যাব দিয়ে। লগত ভাবুকি দিয়ে যে যদি আমি ঘৰ ভাঙি লৈ নাযাওঁ তেতিয়াহ'লে আমাক ঘৰ বাৰী ভাঙি জ্বলাই দিব। লগতে প্ৰাণে মৰাৰ ভাবুকি দিয়ে। যোৱা 31/3/2003 তাৰিখে সন্ধিয়া প্ৰায় 5টামান বজাত মই আৰু মোৰ দাদাৰ পাছানালীত ঘৰ নথকাৰ সুযোগ লৈ মোৰ 3টা খেৰী ঘৰ আৰু মোৰ দাদাৰ 2টা খেৰী ঘৰ আৰু এটা টিঙৰ ঘৰ পদকীয়াজনে জ্বলাই দিয়ে বুলি আমাৰ সন্দেহ হয়। ঘৰৰ লগতে আমাৰ ঘৰৰ ভিতৰত থকা সকলো সামগ্ৰী তথা নথিপত্ৰ আদি জ্বলি যায়। উক্ত ঘটনা সংক্ৰান্তত বিহিত ব্যৱস্থা লোৱা হয়। This is the against us lottery, and we have filed for the FIR in the year 2021, that is we find page number 18. May I see the summary version of it, and we start from page 22. Page number 22.
Yes, read.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে আমি পূৰ্বতে ভকুৱাবাৰীত বসবাস কৰি আছিলো, কিন্তু ব্ৰহ্মপুত্ৰ খহনীয়াৰ ফলত মাটি নদীৰ মাজত যায়। ফলত আমি জাহিৰপুৰত ঘৰ সাজি বসবাস কৰিবলৈ লওঁ। ব্ৰহ্মপুত্ৰৰ বালিচৰ পৰি পুনৰ মাটিবোৰ খেতিৰ উপযোগী হোৱাত আমি ঘৰ সাজি খেতি বাতি কৰিবলৈ লওঁ। কিন্তু উপৰোক্ত পদবীয়াজনে বহুদিনৰ পৰা আমাৰ মাটিখিনি বলপূৰ্বকভাৱে বেদখল কৰিবলৈ চেষ্টা কৰি আহিছে। যোৱা 31/6/2021 তাৰিখে উপস্থিত পদবীয়াজনে আমাৰ প্ৰায় 20 বিঘা জমিৰ শস্য কাটি লৈ যায় আৰু ঘৰ দুৱাৰবোৰ ভাঙি লণ্ডভণ্ড কৰাৰ লগতে ঘৰ টিনপাতবোৰ লুটপাত কৰি লৈ যায়। আসামীজনক এই কাৰ্যত বাধা দিব যাওঁতে আমাক দা কোঠাৰ লাঠিৰে আক্ৰমণ কৰি মাৰিবলৈ আহে। In the year 2021, we have launched this FIR, and Lordship now will file to page number 17. The petitioner, there's a petitioner number 1, 145, 146, and the case number 18/2022. And as per this order, Lordship, the disputed land already been attached, and both the parties restricted to agree into the land. And Lordship now will find page number 24, Lordship, and final judgment passed by the Deputy Commission, order passed by the Deputy Commission in favor of the present petitioner. Page number 24. And as per this order, Lordship, and the last person, page number 26, Lordship, last 2 lines, Lordship, page number 26. The earlier attachment order, last 2 paragraph, Lordship, the earlier attachment order, and in respect of the disputed land from a TL from this court, if any, and is hereby withdrawn and here stand vacated. And the Godavari Revenue Circle is hereby directed to deploy a large mandal to vacate the land, disputed land, and hand it over the possession over the first party of the present petitioner. And subsequently, Lordship, they have launched this all this treasury, and as per the FIR itself is very much clear. So they have.
Yes.
So it's land dispute, Lord. There is nothing happened.
All for CD.
Lordship,
All for CD and injury report, if any. All for both CDs.
and in the wisdom, Lordship, otherwise, Lordship, they are very poor person, they are cultivating the land. There is nothing happened in this, Lordship.
This is from Kamrup, it will come within a short date.
Lordship,
It will come within a short date.
intel project, Lordship, and everything is very much clear, land dispute, otherwise, Lordship, tax house, all this area, Lordship, they are making tax house. But we have already possessed our land. And it is the Deputy Commissioner and Circular report is very much clear.
How many persons? 12,
Yes,
15.
15 minutes. Lordship. All their poor person, Lord. Cultivate them. But police ran after them, Lord. If they are arrested, otherwise there is nothing, Lord. The document, the FIR is very much clear, and it was a shortage. And compliance not with the order is passed by the deputy commissioner. There is no case at all.
Let it come on eighth,
Lordship.
not eighth. Today is first. Can you get it on fifth or sixth?
Lordship.
Let it be on sixth. We'll pass orders. Let us see.
6-6. Lordship.
6-6, heard so and so and so, learned counsel for the petition. Call for CDs in connection with. What is the case number? Kualkusi, River Police Station. Case number 21 of 23. Along with. What is the other CD?
And that is case number of people. That is actually lordship that case is case number under section 145-46.
Okay, then forget it. Call for CD along with
Injury.
injury report, if any. List of six of you.
How much?
It is called for only one city.
One.
How much?
5,
May I please?
Yes, Mr. Hussain.
See petition referral, one is the existence of the college. Two is the Gambura, three is the connection 3 base 12 is the offense under 306 amendment of police.
Annexure 3.
3 base 12.
Is it?
May I? With due respect, it is informed that in 18/5/2023 at about 9 AM, my younger brother Rafiqul Islam, aged 37 years, committed suicide by hanging in his house. Therefore, the family members of the house saw him, and after that, he was taken to Kokeram Hospital. However, he was declared dead by the doctors and sent to Kokeram Hospital for postmortem examination, and therefore the postmortem examination was completed. After that, Rafiqul Islam was buried by the observing Islamic tradition. On the next day, on 19/5/2023, we were all assembled to observe condolence of the death of Rafiqul. Today, on 25/2023 at about 11 AM, while cleaning the room of Rafiqul Islam in where he committed suicide, the sister Momina Begum and Rafiqul's wife and some other people found the piece of paper note, and thereafter there was a hue and cry as to what was written in the paper note. I went there to see what was written by my brother to commit suicide, and thereafter Momina Begum handed over me the said paper note which was written by Rafiqul Islam. After reading the paper note, I found that the reason for committing suicide was mentioned. It is clearly written that one Riyadul Islam, son of Sadan Sas, Muhammad Islam, Shah Kamal Master, Mehboob, Mukdub shopkeeper, and Gaubur of the village conspired to force my brother Rafiqul Islam to commit suicide, and the said note was seized at 2:30 PM by Procedural police station by SI. It is therefore better you will not make any incident now, my lord, after 2 days, this suicide note, so-called, and why using the mala, so-called suicide note was recovered from the house of the while cleaning the room. Now we have mala taken clear stand in para 5 and page 5 mala. Mala, this was circulated in the social media. After having gone through this mala suicide note, mala, we have compared the handwriting with the Ramzan Ali, who is the cousin brother-in-law of the deceased. Malad, we have taken specifically in our petition para 5 Malad. He was written by him, Malad. We have taken
You are not a handwriting expert.
Malad, now we have come to Malad,
Where is the suicide note?
Malad, we have not annexed the suicide note, though we have it is with us, Malad, in the circulated social media, Malad. Malad, now we have come to know, Malad, that deceased is related, almost related, class 2 pass B, Malad. Malad, he cannot write this letter, Malad. Malad, it was the Ramzan Ali, son of Habibur Hussain of same village, who is the cousin brother of the Malad. There was a property dispute, Malad, we have stated, Malad, mind it can have me paid of the my picture. Case file. Well, we are professor still doing Malad, having reputation, Malad, unnecessary putting.
No, but you are not named in the FIR.
Malad, named in there.
All three.
Yes, all three. One is assistant professor, another is Gampura. Is that but a para 5 will make and little form taking little pain.
Can you come to the FIR?
It state that
FIR?
Page 5, paragraph 5.
No FIR.
Page
One.
12 also.
Page 12.
Where are you named there?
Well, it was
Page 13
page
also.
13, my lord.
Last part.
Mominur, last part.
Hmm.
Yazul, son of Momin, against my name was not properly. Mominur.
No, it was-
Master.
It was written by Riazul, who is your son, not you. You are petitioner one.
My nickname is Riazul Islam, son of Saleh. Actually, my father's name was wrongly.
Okay.
And alias Momin. Actually, my name is Mominur Islam, alias.
Hmm.
And
Then
Mukul Shortcut and Gaugura. One Gaugura might say the Gaugura. Petition number 3 is the Gaugura.
Mukul shopkeeper, he is the Gangura. No,
Shopkeeper is another person.
Gangura is another.
Gaugura is there.
Yeah.
And Mominur is another. Three
Art-
petitioner people.
Art Mr. So-and-so learning counsel for the petitioner and Mr. Sich Kora learning APP for the state. So the petition is filed by the petitioner apprehending arrest in connection with so-and-so case. Whereby it was alleged by the informant, namely Saidur Rahman, that his cousin late, what is his name?
Rafiqul Islam.
Who is the person who committed suicide?
Rafiqul Islam.
Rafiqul Islam had committed suicide and had left a note where it was clearly mentioned that the petitioners had conspired to force his, is he brother or cousin brother?
No, Lord, he is the brother.
He's the brother, not cousin, brother. The informant's brother was forced to commit suicide. And accordingly, an FIR to that effect was lodged. Apprehending arrest is anticipatory bail petition is filed. It is submitted by learned counsel for the petitioner that petitioner one is professor,
Assistant professor, Pokeragram policy.
is an assistant professor in Fokiragram.
No, Axel 1 we have added.
Number two is,
2 is the Gaugura.
Good.
Next number.
no, two is a businessman,
No,
three is the Gambura.
3 is the Gaugura.
Accordingly, let CD be called for along with PM report. In the meantime, if the petitioners are arrested, they shall be released on furnishing a bail bond of 30,000 each with one local security of like amount with the satisfaction of the arresting authority and subject to the following conditions. They shall appear before the IU within 10 days and shall not influence any person, not intimidate, interfere or tamper with any evidence and not move out of the concerned police station without written permission of the IU. List on 7th of August.
Item 6.
May be the motive. But page 8 is the FIR matter. But 3 persons are named mother. Page 8 is the FIR, 3 persons are named mother. But and the accused number 3 months. In the FIR, there is no allegation against 3 matter. Not even a whisper against the accused number 3. Only allegation is that I am the father of the prime accused, that is accused number 2. There is no allegation, not even a single line against accused number 3.
Can you read the FIR?
Page 8, Manu. With due respect, I would like to state that on 12/5/2023 at around 2 AM in the night, 4 bags of dry betel nut were taken from my betel nut factory. And thereafter, when the accused number 1 and 2 were filling up betel nut in a 60 kg gunny bag, then my younger brother, namely Dildar Hussain, saw them and caught the accused number 1. Then the accused number 2 tried to kill my younger brother with a sharp weapon by stabbing him in his left side from behind. And when my sister-in-law, namely so-and-so, tried to restrain them, then the accused number 1 tried to kill her with a sharp blade by slitting her neck and injured her grievously. When I tried to catch the accused number 2, then he fled away from my hand by tearing his clothes. After that, I have apprehended the accused number 1 as because he tried to kill my brother and sister-in-law and immediately the villagers came and took them to Moki UD, Nogam for medical treatment, but they were referred to DMK, Guwahati. And there is no allegation against accused number 3 man. The only allegation is the father of the accused number 2. Not even a line, the number with permit.
So why is he named as an accused?
But one, he has been named, my lord, as if the accused number 3.
Who is he?
But he is the father of the accused number 2. Okay.
We had Mr. S.M. Abdullah, MS, NMS, SH Boral and APP for the state. Call for CD along with injury report. In the meantime, if petitioner number 1, petitioner is arrested, he shall be released on furnishing a bail bond of 25,000 with one local security, 30,000 with one local security of that amount to the satisfaction of the arresting authority, subject to following conditions. You shall appear before the IU within 10 days from today, and shall not hamper or temper any evidence, intimidate any witness, move out of the concerned police station without leave of the IU. List on 7th of August.
I'm deeply offended.
Item number 7.
Please, your lordship. The 438 application. FIR request date.
Hmm.
We read the FIR.
Yes.
Respectfully, it is get to state that on last 3/4/2023, my son's is on the mandal of 21 years. Went to Muripara with accused number 2 and 3 to work under accused number 1. But on the instruction of the accused number 1, my son was working at Kamargaon Union from 3/4/2023, and on 13/4/2023 at about 11 AM, my son arrived at home from his workplace. And on the same day, at about 8 PM, the accused number 2 came to my home and scolded my son with slang languages. And in front of my wife and alleged that he has stolen money and gold. Again on 14/4/2023, at about 4 PM, the accused number 1 and 3 made phone call to my son for mobile number so and so and falsely leveled allegation of theft. And my son has been suffering from mental agony and went out from home. And on 15/4/2023, at about 5:30 AM, he committed suicide by hanging on a tree of my house. This is the case of suicide. And he committed suicide on 25/4/2023. He committed suicide on 15/4/2023, and FIR was lost on 25/4/2023. After 10 days, this FIR was lost. And there is no any explanation of delay. After he committed suicide, the reason based on to the deceased. But the actual fact is that he left the work and came home. And the petitioner number 1 and other 2 persons who introduced the victim with the accused number 1. That you have given the person to work, and in the middle of the work he has left. So they came to the house of the deceased and requested to go to the workplace. And it is true that he stole some money from the pocket of his roommate.
Let us call for CD.
And on the next day, he committed suicide.
Let us call for CD. Pardon, Mr.
Even
So-and-so.
I may be protected, my lord, I will cooperate with the police, my lord, in the investigation.
Call for CD along with postmortem report.
He committed suicide in home, my lord. FIR it is clear that, my lord, the suspicious murder is not there. The informant himself says that he committed
In the
suicide in his
meantime, if
house.
the petitioner is arrested, he shall be released on furnishing a bail bond of 30,000 with one local security of like amount to the satisfaction of the arresting authority. Subject to following conditions, he shall appear before the IU within 10 days from today. He shall not intimidate or influence any person or temper any evidence or hamper with the investigation, and not move out of the jurisdiction of Kamalpur PS without written permission of the IU, released on 7th August.
Am I protected, man?
Always.
For admission, item 8.
This will take up in the second half.
No,
Let us complete the bail matter.
Well, Lordship, in the meantime, mildly, from the.
okay.
Item 9.
Wait, legal order. For individual, I have come seeking placement of the FIR. The crux of this matter is that, an FIR was filed, against one Panna Kanti, Panna Dev, by the present informant. Alleging, my lord, criminal breach of trust. Similarly, my lord, I was also subjected to, my lord, criminal breach of trust, my lord. This accused person has committed, my lord. And I also filed an FIR wherein this Panna Dev was arrested, a sworn arrest. Now, my lord, at the time of committing the offense, my lord, this Panna Dev issued some checks to the informant of the present case. And I was also issued similarly some checks, my lord. The informant checks got dishonored. My checks, I was paid, my lord, a considerable amount of money. And because of that reason, my lord, the investigating agency of the present FIR, my lord, he, my lord, implicated me also in this particular case, my lord, alleging, my lord, that I may involve the commission of such an offense, my lord. If for a moment, my lordship may kindly come to page number 27, that is the charge sheet,
No, let us first go through the FIR.
my lordship. That my lordship will find at page 22. Page 22. May I read?
Yes.
With due respect and honor, I would like to inform you that Mr. Panna Dev, son of so and so, owner of Sid Ganesh Traders, Ulubari, Guwahati, and permanent resident at Silchar, so and so, Lord, who was having business relations with so many people around Guwahati since last 3 to 4 months. Now it has come to know that he is a fraud and defrauded so many business concerned, including my firm, Gang and Sons, PR Fukon Road, Pennsylvania, Guwahati, to the tune of rupees 1,35,78,188. That apart, in order to cheat all the honest businessmen, he removed signboard of his business firm and changed and keep on changing his residential official address as well as mobile number. This is the summons after. And the charge sheet, my lordship, will find at page 27. Page 27, married law.
Yes.
The brief of the FF of the case is that on 26/10/2021 at 7 p.m. complainant Bhushan Kumar Jain of Pennsylvania lost an ejahat to the effect that the accused person has been ordered and received grocery items like sugar, edible oil, and pulses from the firm Gang and Sons belonging to the complainant Sri Bhushan Kumar Jain with effect from 1/10/2022. Total value of goods is rupees 1,35,78,188. But the accused has been found absconding and submitted checks by the accused are also become bound. As such, the accused is found fraudulently siphoned the tune of rupees so and so, hence the case. Then case 28, that is the allegation against me. During investigation, it is found that a total amount of rupees 65 lakh has been transferred to one person, namely Pinak Pani Roy, from the account number so and so, so and so, and so and so, belongs to Panna Dev. Suspect that Pinak Pani Roy may be involved in the crime, as a huge portion of the amount of Panna Dev has been transferred to the 3 checks provided to him. May be involved. So I already had filed, my lord, the FIR which I had filed, my lord, that my lordship will find at page 66.
Page number,
Page 66 is the FIR filed by me.
yes,
My lord.
please read.
With due respect, I beg to inform you that I am builder developer by profession. I have a commercial property at 31 so and so Miller. I let out one part of the said property to Sri Panna Dev, proprietor of Pesos Day Trading and Supply for a monthly rental of rupees 1,50,000 only from September 2019. Apart from that, at the inception, he introduced himself to be a supplier of iron rod, TMT bar and cement and approached me for supplying the material. And as being a builder, public developer, having various ongoing projects at various sites in and around Guwahati, I welcomed him and accepted his proposal. However, during the tenure of about 2 years of his stay at my commercial complex, I advanced him money for supplying the material. Owing to the outbreak of COVID-19 pandemic, he could not supply the materials on time, and finally he told me that he will not be able to provide me materials and rather assured me that he would return the money taken from me. Accordingly, on dated 26/10/2021, he sent a person along with 3 numbers of checks amounting to rupees 65 lakh. However, be to mention herein that during his stay at my premises, since the spread of COVID situation, that is April 2020, he completely defaulted to make payment of my house rent. The house rent accrued against Sri Panna Devi is approximately rupees 28,50,000. Recently, it has come to my knowledge that he has absconded and defaulted to make payment to many other persons. Further, till date, I am entitled to receive an amount of rupees 83,50,000 approximately from Sri Panna Devi, out of which I have received an amount of rupees 65 lakhs only, and rest of rupees 18,50,000 I am yet to receive. Now the said Panna Dev has already absconded without returning my whole amount and thereby cheated me. And it was so nearest, my lordship would find at case 68. It was so nearest also in my case. And the honorable court below, without applying its judicial mind, taken cognizance also against me. Now the matter is pending in the
Where is the order?
my lordship. Yet I have not annexed because the matter is fixed for consideration of charge. And my lord, I have already served with the copy, my lord, under section 207 CRPC. And I have already placed before your lordship the copies of the statements recorded under 161 CRPC by way of an affidavit. But on the last of it,
Can copy was called for that has been received.
That is received.
Yes.
Hmm.
That is still in the process.
Lord, the records have been called for.
Hmm.
But on the last occasion when this matter was listed, my lord, the honorable court was of the opinion that the city was required.
You are for the respondent too. What do you have to say? You have not lodged a complaint against him.
No, but actually, the lead counsel is absent today, is out of station, so I am the proxy counsel.
Who's for the council? Who's the lead council?
BDEC.
I fail to understand why my lord, the investigating officer, my lord,
When is the next date fixed?
on 19 June, my lord.
This time, 19 June. Yes, madam.
It's a cognizance has been taken and current proceeding at the
No, prima facie, there is no material against him.
it is on the consideration at the stage of pending in the stage of consideration of charge.
Hmm.
We also may call for the after the status report process
My lord,
Huh?
after 19th of June
From?
from the concerned track court.
No, means you want the scan copies, scan copies.
Scan copy, not scan copy perhaps already received.
Hmm.
Only the status report will require the stage of the present proceeding or current proceeding. After 19th of June.
I'm submitting my lord, that is, charge has not been paid.
Next date is fixed for 19/6 for their personal election has appeared.
For framing of charge.
Yes, my lord. Yes.
No, no, 19 June is for what?
Consideration of charge.
Consideration,
Yes.
yes.
So my grievance is, my lord, at the very inception, I do not know who the informant is. He doesn't know me, my lord. There is absolutely no misappropriation of any amount, my lord, with this particular informant, my lord. Absolutely no involvement, my lord. I have filed case against the prime accused, my lord, and the investigating officer, my lord, implicated me in this case, my lord. Also, my lord, putting an allegation that I may involve in an offense, my lord. This is absolutely abuse of the process.
And what is the stage of the FIR that you have filed?
That is most probably, my lord, pending investigation.
Yeah,
He was arrested, my lord, subsequently. I was
You get
informed
status report on the second FIR.
Not.
What is the stage?
Not.
So
What
far
is the
as-
status in terms of investigation?
Yes. Sir.
because, my lord, that case, my lord,
Your matter is fixed on 19th.
my lord.
So
But my lord, 161 statements I have already placed before this honorable court. Not a single word against me. No material at all, my lord, against me. No witnesses has said anything.
court may not proceed to frame charge against you. Why are
My
you
lord,
apprehending?
every date, my lord, that is justified. That is why I have invoked the my lord, powers under section 482 before this honorable court. My lord. That is why I have come before this honorable court.
We considered this after 1960.
No, that my petition will get infructuous, my lord.
You'll have to consider it before 1906.
What should we call for the status report?
We will direct the trial court to proceed in the matter, but insofar as his case is concerned,
Not. Sir.
proceedings will be kept in abeyance
Not.
until the status report comes.
My lord.
Lord, should we call for the status report before 19th?
Before 19, then next date is fixed on 19. So all right, we'll fix it on 14th.
No, sir.
14th. So we'll consider your prayer on 14th
No.
because your next date is on 19th.
My lord.
Heard the counsels for the parties. Let status report be called for from the court of SDJM 2,
My lord.
SDJM S2,
Complete metro.
Kamrup Metro, Guwahati. Regarding PR case number 3077 of 2021 in connection with Panbazar case number 576 of 2021. List again on 14th of June. Of June. And we are not putting it, but you can file any objection if you want. Up to you. 14th.
Item 10. Item number 10.
I am appealing for the respondent wife,
Petitioner is not here.
the maintenance case.
What is the amount directed to be paid?
Actually, this 5,000 was the amount, but this could state it on the ground that they have pleaded adultery.
No, no. What is the amount to be paid?
To be paid 5,000.
The court has directed.
10,000.
Huh?
5,000 to the daughter, 5,000 to the mother. But this court lordship is directed only to pay to the daughter.
Daughter. Okay.
And that also they are not paying lordship regularly.
Let the petitioner come.
Then
None appears for the petitioner. This next week.
Next week.
This next week, Mr. M. Ahmed appears for the respondent. Next week.
Item number 11.
Deposited the 25% of the compensation. And my lord, here in this case, my lord, we will pay the rest amount within 6 months. My lord. That is my prayer, madam.
What I take your lordship to page 6 only. For a minute.
Page 6.
Both the court has filed concurrent finding against which this revision is filed on one ground, my lord. I take your mail with my lord.
Yes.
For that now his commercial building with 15 acres land at Panigaon Pinari covered by dark desk, Kepi Patta desk, situated at desk under North Lakhimpur Revenue Circle is acquired by the Deputy Commissioner Lakhimpur for construction of new highway connecting from Banodhara to Nagaland, and as such the petitioner prayed for compromise the matter and also prayed for some time to repay the said amount before this honorable court till he received the compensation amount against the acquired land or in any other way. This is the ground for revision against the concurrent
In this stage, my lord,
What was the finding?
My lord, I take your lordship to the trial court finding. It is at page 16 of the petition.
paragraph 22, ma'am.
Paragraph 22. We have produced 5 witnesses and the accused is not addressed any witnesses and has only denied member.
Yes, yes.
The concurrent findings at page 20, my lord, at page 16, paragraph 22. Here with my lord.
Yes.
My lord, I am reading the relevant portion. Considering the nature of the offense and the facts and circumstances of this case, accused Sri Ashwatananda Bora is convicted for the corrected as for the offense under section 138 of the NI Act 1881 and he is sentenced to undergo simple imprisonment for 6 months and further to pay a fine of rupees 4 lakhs. The total fine amount as and when realized shall be handed over to the complainant as compensation. The fine amount is imposed as rupees 4 lakhs as the total said amount is rupees 3 lakhs and more than 5 years have passed from the date of issuance of the said. It is further directed that the convicted undergo simple imprisonment for another 2 months in default of the payment of fine. This was the trial court finding against his measure the team of files before the honorable session has and the relevant order is my lord
The appeal stands to dismiss.
this misconcurrent findings and my lord against this revision is fine on the ground that ground my lord that I have read over.
So, the advocate court will have no advised to compromise the matter. He contested and contested. Now, we have advised him to compromise the matter and pay the compensation amount.
So did you deposit 25%?
Yes, today, madam, we have deposited.
Today.
Today. Actually, madam, there was a mistake from him, my lord. He deposited the amount in the junior's account. That's the he has deposited.
Last occasion, you was having cafe
Actually, I was out of station, madam. That is why I was pleased to be. And medical ailments are also there. I was annexed to that. I remember 281.
This person has issued the check in the year, my lord. He has issued the check on in the year 2014. From 2015, he has this running, my lord, forensic of justice, my lord. The others are past, my lord. And
Really, my lord, our 6 months time may be given, my lord, you will pay the entire compensation.
What is the 25% amount?
4 lakhs of 25% of 1 lakh, madam.
1 lakh.
I got the initially when the letter was filed, it was fixed, it was came before the honorable court on 20th of March. And the letter was fixed on 26/4. There was no stay over. In between, the petitioner has filed a petition on SI, my lord, in which an order was passed on 11/4, my lord. With that, the 25% of the registry will be 25% will be deposited before the registry on the next day, and in between it was stayed, my lord. On last occasion, it was not deposited. I raised this objection with regard to the IA, and today it was filed without matter with regard to the.
You bring it on record, you file it. Right from IA, but why was it deposited in his account? You should have asked him to deposit it before the registry.
You're also he's an oldest person and
Oh, oldest.
element is there.
You are stepping into the shoes of the petitioner. That is not your job.
Will be undergone protect the way.
Get it, all right. You bring it on record. Mr. J.R. Gogoi, JC Gogoi, learned counsel for the petitioner submits that in terms of the earlier order dated 24/05/2023, petitioner was directed to deposit 25% of the compensation amount before the registry of the court. It is submitted that by check dated 1/6/2023, the said amount has been deposited through the advocate on record, Mr. Samir Ali. Samir.
Yes, only.
No. S. Ali stands for what?
Only SMI.
Samim.
Yes.
Samim Ali. Full stop. The learned counsel is permitted to bring the details on record by way of an additional affidavit. List again on how much time you require.
6 months, only 6 months.
No, you bring this on affidavit first.
Next week,
Next week.
affidavit will file within 1
On 12th.
12.
MSSG Bora, SG Garwal appears for the respondent. List again on so and so date. It will be ready for time. You take it back, file an affidavit to bring it on record.
The hearing again 12 and 13.
Time being.
Diary
Receipt. All right, time being. At 2, second half. Yes.
14.
Do that again. Oh, sorry.
Yes, diary. Here one thing, my daughter, postmortem report not available.
That has been there since the last order.
In your books.
Postmortem is also required. Why is it not there? It should be there.
No, my lord, the diary available, my lord, without postmortem.
How is it possible? Why the postmortem report is not collected?
I just page 9, madam.
Why were you arrested?
No, I'm not arrested, no.
Why are you apprehending arrest?
My lord, at page 9, my lord. I was not there, my lord.
Then why are you apprehending?
My lord, please.
Why are you apprehending?
My lord, there is no beating, my lord. At the time I was not there, my lord. No beating there, my lord.
I understand you are not there, but then why are you apprehending
My
arrest?
lord, police is searching my every house.
Why is the police searching your house?
Yes, every police house.
But everyone is not before the court, only you are there.
Yes.
Why? What is the reason why that you are apprehending arrest?
Because somebody probably, my lord, gave my name, my lord, but I was not there, my lord. That's my lord, I want, my lord.
Heard Mr. So-and-so learned counsel for the petitioner and Mr. D.V. Gogoi learned APP for the state. This court, by the earlier order, had called for case diary. It is submitted that the case, along with PM report, it is submitted that case diary is called for has been received. However, PM report not received. Let the PM report be called for. When can you get it?
From Samaguri, my lord, mix of June, my lord, any day.
Released on 22nd,
Yes.
22nd June.
Till then, my lord.
In the meantime, if the petitioner is arrested, he shall be released on furnishing a bail bond of 30,000 with one local security of like amount. subject to the satisfaction of the arresting authority. We shall appear before the IO within 10 days from today. We shall not intimidate any person or witness. We shall not hamper or tamper with the investigation carried on. And it shall not move out of the jurisdiction of Samaguri PS without written permission of the IO. List again on 22nd June.
15,
15 diary notice.
Diary not received. When can you receive? When will you receive it? Chirang,
Okay, second time today. Here also not.
where is the FIR?
FIR case 10 months.
10.
But the typical mistake here, the first line it will be 14-1, the only title 10-1.
So you'll have to wait for interim orders, sorry, case diary to consider your interim prayer. You already stated that we'll consider after receipt of case diary. When can you get it? 20?
Yes.
20 June. Call for CD.
Responsible protect. One, it's not only very responsible party.
No, we have already ordered that we'll consider upon perusal of the CD. That order is already there.
Therefore, we let
Short.
already two days, very time.
We have given you 20, we can make it 19 if you want.
19.
19. June.
A little bit of redundancy about item number actually 10. I was not here, it was called.
Now your counterpart is not here.
Your lordship, whatever take your lordship, it's only my name.
Okay. Item number
12 and 13.
item number 10.
10. Item we have kept it next week.
12
12 and 13.
Presence.
Presents. All right. Item. Item
And 12 and 13 your lord.
12 and 13.
12 and 13 also I'm appearing.
No, you are referring to which matter first?
Just 10.
Item
I
10,
did not-
Mr. Y.S. Mandan appears for the petition. Yes, then 12 and 13,
12 and 13 your lordship has actually fixed it at 2 o'clock.
because somebody meant to mention.
So I was on late in court number 1.
Ah,
I have to go in the second. Can it be taken up?
all right, let us complete this before hearing, we'll take it up. Just wait, 3-4 matters are there, we'll complete it. Take it.
Item 16,
Yes. Here my diary received without injury report, my lord, case of 326. My lord, since the two occasion I am submitting that the injury is not 326, my lord. And on the last occasion, your lordship said that on the next day we will consider your interview, my lord.
We'll consider, we are not refusing not to consider your injury, we'll consider.
My lord, this is, there is a cross affair, my lord. This is between two boys on one side and the two boys on the other side. There have been exchange of fist and everything, but these are no grievous hurt, no sharp weapon, nothing, my lord. These are all exaggeration.
Knife and iron rod,
These are all exaggeration, my lord. That is why had there been any such injury, that would have been the first page in the case diary. Nothing of that sort, maybe some exchange of fist, my lord, two young boys on either side, my lord.
okay, when can you get the injury report?
My lord, from Bulahat. 16. My lord, will just give me an opportunity to go and record my statement, my lord. On the last occasion also, I made the submission, your lordship.
I heard Mr. M. Biswas, learned counsel for the petitioner, MS B.B. Gugoi, learned Mr. B.B. Gugoi, learned APP for the state. This AV petition is filed with the petitioner apprehending arrest in connection with so and so case. Golaghat PS case 145 of 2023 under section so and so. This court by the order dated 16/5/2023 and 24/5/2023 all for the case diary along with the injury report. So today when the matter is listed, then a DPP submits that although the CD is received, injury report is not,
Without injury report.
no injury report is available. He therefore prays for further time. Accordingly, let the CD. Do you need to send back the CD or you can call for?
Only injury report is required.
So let the injury report be called for. To be produced before this court by the next date fixed. Meanwhile, if the petitioner is arrested, he shall be released upon furnishing an bail bond of rupees 30,000 with one local security of like amount to the satisfaction of the arresting authority. Subject to the following conditions, he shall appear before the IO within 10 days from today. He shall not intimidate or influence any person. He shall not hamper the investigation or tamper with any evidence. He shall not concern police station without leave of the IO. Let the matter be listed in month of July.
23, madam,
23,
or any date thereafter, madam.
23 July is
Not
Sunday.
July, madam. We are on June, madam.
So we'll list it in July. 27 July.
27, I'm getting.
Let the CD be returned back to call for the injury report along with updated CD.
I'm sorry.
For orders, item 17.
Yes, Mr. Prasad.
Matter delay of 1077 days matter. Filing date criminal fee. Under in the document that I have arranged, 2% were completed matter.
Let us issue notice. Anyone in the,
Other person has already filed an appeal,
Ah.
which is pending matter. That has been admitted. Mr. Kalita appeared for the informant in that matter.
yes, any objections?
Matter is, the instruction, let it come after a week. In the meantime, we can obtain the instruction and file the local appeal.
Let us issue a notice.
Ma'am.
Let it come after a week or 10 days, let him have his instructions.
Ma'am.
Heard Mr. B. Prasad and counsel for the petitioner, this IA is filed seeking condonation of delay of 1077 days that had occurred in filing the appeal against the judgment and order dated 19/3/2018 passed by Session Judge Kamrup Amingau in special case POCSO case number 09/2014, whereby the petitioner was convicted to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 5,000 and in default to undergo rigorous imprisonment for 2 months. When full stop conviction was made under section 5G of the and 6 of the POCSO Act. Full stop. Let notice be issued. Returnable 2 weeks. Since Mr. B.B. Gogoy and APP appears for State of Assam and Mr. D. Kolita appears for the respondent number 2. Notices are waived, however, sufficient extra copies of the IA be furnished to the learned councils within the course of the week by tomorrow. Let the matter be listed after 2 weeks, enabling the learned APP to enabling the respondents to obtain their instructions. 22nd of June, list on 22nd of June.
Supplementary list for orders, item 33.
Lordship, my lord, actually, this case was registered on 26/5/23, my lord. And then lordship granted interim protection on 24/23.
It is need to be listed on 23/6.
Yes, but my lord, on that day, due to one of a mistake,
Ah,
we did not play for an interim continuation. So that only we have played today. Interim order passed on 24/23, we can make a clear till the next day. That's right. For your lordship, please, also request, because the other side is also present, victim side is also present.
no, let it come on 23/6.
Right. Till then, it shouldn't make any legal thing.
Matter was directed to be listed on 23/6/2023. Learned counsel for the petitioner, Mr. M.U. Mahmood, submits that by oversight, the prayer for continuation of interim order was not made on the last date fixed. Therefore, the matter was mentioned and listed today. Praying for an order to direct continuation of the interim order granted by this court by the order dated 2004/2023. Accordingly, let the matter be listed as fixed earlier on 23/06/2023. Interim order dated 2004/2023 shall continue in the next date fixed. Mr. P.D. Gogoi, learned APP appears for respondent number 1 and Mr.
D. Hussain.
D. Hussain appears for respondent number 2. List accordingly.
Bail hearing against 12 and 13.
Yes.
Rising out of the same. You know, you kindly take the FIR of page 14(1). This basically there is a land is, I'll come to that before you know, you kindly take up page 1(4). FIR is of 10/5/2023. The date is also important.
Hmm.
Document for page 14.
14.
1(4).
Yes.
This is the FIR type copy.
Ah,
And your lordship, 17 is the estimate.
yes.
Basically, with due respect, I went to state, I have ownership of land.
17 or 16. Page number.
No, it was-
Page number, your page number.
Page number 14, it's 1710.
I know. 17.
There are two matters.
Oh, you are referring to this.
1749,
Okay.
arising of same
You are now addressing
1710.
17.
Item 12,
Yes.
page 14 is here.
No, 12 is 1749. I think 14749 is item 12.
Ulta, actually,
Now you want to address on this second matter. You are addressing on 1710.
I am addressing on 1710.
All right.
Here, page 14.
14. Yes. Yes.
Now, what has happened, your lordship will kindly straight away turn to page.
No, kindly read the FI first. Let us see.
That was when date is important, 10/5/2023. With due respect, I beg to state that I have ownership of land measuring 4 katha, 1 lecture of land at Ananta Pot at the Pisto under the school revenue circle of Eltola Musa, Potta number so and so, that number and Potta number are 15471133. I have 3 SME style house on the same land with the holding number so and so. Even I am not at house, Vishwakarma has been living there for the last 10 years and Hidayat Prasad has been living there for the last 1 year. On 4/5/2023, a group of 10-12 unidentified persons armed with weapons entered the said premises and threatened the tenants, tied them up, robbed all the valuable belongings present there. They also made the tenants to vacate the land forcefully. When the tenant made hue and cry, some neighbors came and one of the miscreant is named Hemantoboro alias Sumit. Therefore, I request you to register a complaint based on the information provided by them regarding the threats and attacks against me and the people staying as tenant and take necessary action so that the accused get proper punishment.
I want to get my land back. This is basically but registered under 395. Now your lordship will kindly turn to page 40.
Hmm.
Page 40, your lordship, is the civil suit. This civil suit was filed on 8th of May 2023. 2 days prior to lodging of the FIR. And the incident they have stated is on 4/5/2020. That is about 6 days after the incident, they have lost the FIR. There is some delay there. And secondly, there is 2 days after this suit has been filed, this FIR was lost. Yet the respondent name is the same person, Ram Shiromani Tiwari, who is the informant in the present case. Now, the whole issue has arisen out of this. Here, your lordship will find there is a discrepancy in the tag number and patta number with these two letters. That your lordship will kindly verify from the CD, because they have given in the file specifically they have given a wrong tag and patta number, so that they are not covered by this case in the civil suit. So your lordship will kindly verify that in the CD whether the tag number that we have filed civil petition, civil case suit, title suit, as well as an injunction petition. This was filed on 8th day of May 2023. And the second on page 50 is the injunction, application for injunction, that is also on the same day on 8th year, it was filed. On the second order 39, rule 1 and section 150. These two cases, your lordship, are, though they have given the numbers are different in the FIR, that is 1547 and 1133, here it is different tag number and patta number. But the issue in both the cases are same, and because of this, they file it. In fact, 6 days delay. Why they have waited for 6 days in this case? It is not a case of rape or something. It is a case where they have alleged that some people have went into the house, threatened the tenants, taken away their belongings and robbed. It has, why is the delay? They have not explained the delay in their FIR. And these persons, your lordship, those who have filed the suit, are the persons who are actually holding the land. Nokul Boro and
This is in Hindi.
Yes, madam. I may read it, madam. If you allow. And something like that, complainant statement, madam, more about madam, that accused arrested person, madam, their statement also there. I mean, Hindi, please. Easy to categorize later statement.
one more thing, your lordship, before going into the second, there is one more aspect, your lordship. This is with regard to only two persons. They are female, your lordship. I'll just point out one specific order that is at page 26. Before going into the CD, just one moment, page 26, your lordship. These two ladies. Page 26 is the order of the office of PS case. It was before the judicial magistrate first class order, dated 11/5/23. Kindly for a moment, I'll take your lordship to one paragraph. Lordship, page 26.
No, who are the petitioners?
They
Who are the petitioners?
persons who were actually staying in that place.
Who is the owner of that place?
The owner of the place, actually, your lordship, Nokul Boro and Bisupo. They have filed the case, and these are the tenants who are actually staying. And your lordship will kindly see page 26 for a moment. I will just read one paragraph. The last paragraph at page 26 for a moment.
It is pertinent to mention that the accused, namely Srimati Korabi Chaudhary, has an infant child, namely so-and-so, aged about 3 years male. As such, the said infant child of the accused is to remain with her in judicial custody. I have also gone through the medical report of the said infant. And next page, Your Lordship. Also, co-accused, Srimati Himadri Sunwal submitted that she is 5 months pregnant. In fact, 2 ladies are also under detained and are in jail. One is a pregnant lady and another with a small minor child of
And they are
3
what?
years.
They are petitioners 6 and 7.
They are petitioners 6 and
7.
7. So that is
Yes.
one part.
Yes.
मेरा नाम विश्वकुमार सुधड़ी है। मैं 50 साल का हूँ। मैं पिछले 10 साल से जिवारी जी के घर में रहा हूँ। उस दिन मतलब 4/5/2023 तारीख को दिन में 1 बजे कुछ लोग हमारे रूम में आए और हम लोगों को धमकी मार के वहां से निकल जाने को लिए बोला। उसके बाद वो अपने मालिक फोन किया और कुछ बताया। उसने हमें वहां से जाने को लिए बोला घर में ताला लगा के। लेकिन जब मैंने मालिक को बताया हुआ बात को उन लोगों को बोला, तब उन लोगों ने मेरा बात नहीं माना और हमें घर से निकालने दिया। उन लोगों का नाम मैं नहीं जानता और उन लोगों ने हमारा सामान वहां से लूट कर ले गया। उसमें से कोई लोग लकड़ी हाथ में लकड़ी भी आए थे, लकड़ी लेकर आए थे। हमें वहां से निकलने के बाद लोग जमीन और रूम्स अपने कमरे में करते हैं, कब्जे में करते हैं। That is, he was a caretaker, my lord. He was an eyewitness. And here, my lord, section those edit, my lord, 395, etc., my lord. I think that land dispute was there, my lord, among them. And my friend has annexed Jimadali, my lord, his petition. That is showing the name of the owner. Nokul Bodo Sumita.
This is there in the Jama.
No, what is the DAG number? What is the land description?
That number, but that is mentioned in the FIR.
No, FIR we know. What is there in your CD?
CD, my lord, they have not inquired about the Jama, Mani Patam, only my lord, 395 section. So accordingly, they investigate, my lord, police.
Robbery.
Yes.
That is Dokai. That's why.
Dokaitry. So what have they recovered?
So that is, my lord, the 395, that is not, I think, my lord, the 395, that is not there. From diary, it shows that, my lord. So land dispute was there, my lord, they tried to, my lord, grab the land, my lord, that is all right.
But it's not under land grabbing.
That is not
Land grabbing
registered
act.
under land grabbing.
It is filed under Dokai. And the Samabandi of survey villages that I have annexed in both the two of the land that I have mentioned. That's here Nokul Boro and Nokul Boro name, and the other one, the name of Pichu Boro is there. But the only issue that it should have come in the city because that tag number, patta number is not existing. I mean, this
No, the fact that this land belongs to Nokulboro, you may be right. So whether the petitioners are staying in Nokulboro, from where do you say that?
the petitioners actually were staying as tenant in the land of Nokulbo. These people, how they have come, your lordship, nobody. Now, it is actually the other way around, it seems. It should have come out in the CD, I don't know, I cannot say what has happened actually there. But as per my instructions that and there is a delay, where is the explanation of that delay? Why they have made it so late? There is a dispute of land, there are 2 cases. These people have also have claim in that particular land. These people are already staying in the land, Nokulboro and this particular borough are the landowners.
They could dispute it, that is dispute, they could already case before that is decided in the civil suit. But that's a different. Why do you know this has to be? What is the? That's why to be heard nothing is difficult.
They try to dispossess matter.
Mr. Counsel, also heard Mr. AP Goel and APP for the states. This petition is filed by the petitioners. 7, 1, 2, 3, 4, 5, 6, 7. Trying for bail as they were arrested in connection with PS case number 259 of 2023 under section 395 of IPC. Postal. Learned Counsel for the petitioner submits that in connection with the said case, petitioners were arrested on 10/5/2023, and since then they have been in custody. Postal. It is submitted that an FIR dated 10/5/2023 was lodged by the informant one Ram Siromani Tiwari, alleging that some persons who were staying as tenants in houses built over a plot of land measuring 4/1 lecha at Anantapot at Petisto under the school revenue cycle of Beltola Moza during Patta number 44 and tag number 15747 of N1133. And they were attempted to be a group of 10-12 unidentified persons armed with weapons entered the said premises and threatened the tenants, tied them up and robbed them of all their valuable belongings. Also, they also made the tenants vacate the land forcefully. When the tenants raised the hue and cry, some of the neighbors came out. Also, one of the miscreants was identified as Hemanto Boru. This Hemanto is not arrested. Hemanto Boru.
No.
He is not arrested, or he is there in.
Sumit Boro is in the next case. Hemanto alias Sumit Boro is in the next.
Okay.
In fact, Your Lordship, I forgot to mention one thing. The status quo order was also given by the civil court on 8, saying that the 8/5/2023. And then they filed the FIR on it.
And counsel for the
Page
petitioner
number
submits
61.
that it was alleged that these miscreants issued threats against the informant and as well as the people staying as tenants on the said land also. Upon the FIR being received and registered as Bokisto PS case number so and so, investigations were initiated and the petitioners were arrested on the same day, and since then they have been taken into, they have been in custody since also. Learned counsel for the petitioner submits that this is a land dispute and a civil suit between the two parties. Are pending before the court of civil judge Kamrup Metro. Civil judge number 3, Kamrup Metro also. It is submitted that the defendant in the suit is the complainant in the instant FIR. Full stop. The plaintiffs in the suit claim to be the owners of the land on which the present petitioners are residing. Also, learned counsel for the petitioner submits that the allegations made in the FIR are false. The petitioners have been residing on their land owned by Sri Nopul Boro, Vishu Boro, and Nopul Boro and Vishu Boro. Also, they are absolute owners and possessors of a land measuring 2/9.5 hectares, covered by tag number 1473 of Patta number 1737 and tag number 1477, covered by Patta number and Patta number 1311, situated in Revenue Village, Bor Fazai, Moza Beltola, under Dispute Revenue Circle in the district of Kamrup Metro. Both these two lands are abutted to each other. Also, learned counsel for the petitioner submits that the pursuant to the incident, which was alleged to have taken place on 12/5/2023, the FIR was lodged after 6 days on 10/5/2023 without there being any explanation for delay. So meanwhile, the suit, the title suit being PS number 270 of 2023 was filed. What order was passed in the suit?
Court order was also passed on 8, your lordship will find that page 60 is the title suit and the injunction order at page 61.
An injunction order passed in MJ's
But page
Miss
62,
J case number
Status quo was that.
4455 of 2023 in connection with title suit number 270 of 2023 was passed on 8/5/2023, directing both parties to maintain status quo with regard to possession and alienation of Schedule A and B land till the next date fixed. Learned counsel for the petitioner submits that knowing fully well that there is an injunction order passed by a competent court of civil jurisdiction, the petitioner had falsely making false allegations against the informant making false allegation against the petitioners had lodged the instant affair after 2 days of the grant of the injunction order, which is 10/5. It is further submitted that the land details are wrongly mentioned in the FIR. The correct details are found in the body of the plaint as well as referred to in the injunction order dated so and so. So, learned counsel for the petitioner submits that the petitioners are mere tenants living on the land, which is of which the plaintiffs in the title suit number so and so claim are the absolute owners. Therefore, there is no scope for the informant or any of his tenants to lay claim over the said land. So in any view of the matter, the issue is pending before a competent civil court. Full stop. The learned counsel submits that the petitioners have been falsely accused and have been detained by the police in a matter which is essentially a civil dispute. Therefore, the prayer for bail be granted. Mr. B.B. Royal Learned APP has produced the case diary. Also, perusal of the case diary reveals that the FIR, the investigation is proceeded upon only on sections 395 IPC. Also, it is seen that both parties, namely the petitioners as well as the informant and his tenants, claim the land to be their own. Also, it is also seen that there is a title suit presently pending disposal before the court of so and so. The investigations in the matter has progressed. Statements of the witnesses have been recorded. Also, upon due perusal of the CD, no specific materials are found against the petitioners which incriminate them at this stage of investigation. Also, no materials are found to suggest that further custodial detention of the petitioners are necessary. Also, no materials are also seen from the case diary to suggest that release of the petitioners at this stage of investigation will cause impediment to the investigations being carried on by the IO. Also, taking all the above into consideration and upon hearing of the learned counsels for the parties, this court is of the view that the prayer for bail can be granted and the petitioners so and so petitioners be released on bail. Also, they shall be released on bail upon furnishing a bail bond of rupees 30,000 with one local security of 30,000 each on one local and one local security of like amount to the satisfaction of the arresting authority, subject to the following conditions. They shall appear before the on each and every date as required till completion of the investigation. They shall not move out of the jurisdiction of the Boquisto police station without the written permission of the court, competent court. Bail to be furnished with the satisfaction of CJM Kamru. CJM Kamru. Satisfaction of CJM Kamru. Kamru Metro.
Second same order. Only one petitioner.
He is the main culprit.
His name is there. Sumit.
He is the main culprit. He's been identified.
Yes, he was identified.
Okay, disposed, same order. CD return.
Much of it.
For hearing item 18,
Baकी वही कर लीजिए। Hearing topic. Bail hearing orders, motion leftover. So. Yes. You are not well, we are told.
Not keeping well.
Then why are you coming? We did not reject the prayer for adjournment. We said we want to see why it is parted. Do we not release it from parted?
No, madam. That's why I have come, madam.
Why?
Let me heard.
You are not well, we don't want to compel you to
No
go.
matter, I did the factual notice.
No, that's okay. You will do it on some other date. There's no hurry. We want to know what was the issue about.
Madam, perfectly, the complaint is I was removed from service. Because the judges,
IOC,
I mean, HPC.
HPC. You appear for the respondent.
Sure.
When is convenient? When is it convenient?
Next week, any day, madam.
Next week, any date. Second. No, sorry. Not 22nd. 15th June. At the request of Mr. B. Chakraborty, the counsel for the petitioner, matter is deferred till 15th of June for hearing. Mr. MP Sharma for respondents.
item number 19,
Some adjournment. There is an adjournment slip circulated.
Yes.
Have you received it?
Yes. I have given my signature. The only problem is that he appears on behalf of Sakia. But on some days she could not appear, and thereafter another legal counsel was appointed. I was appointed she is appointed in her place.
Then why did you appear? It is already ordered. It's already ordered. You are ready for hearing.
Because time I was not aware of this development. It
Hmm.
will come any day next week, Lord.
All right, list on 20 June. Earlier, there is no dockets, no vacancies available. 20. List on 20 June. At the request of the learned counsel for the petitioner.
This is shown listed for hearing, but it is to come up for orders for consideration of my aid application.
List for orders. It will be listed for orders.
Items 20 and 21.
It means a lot.
Hmm.
Lordship, in this matter, we newly engaged lordship. We have filed our wakalatnama yesterday. Lordship may allow
At the request of Mr.
our declaration.
R. Deka, who submits that he has been engaged in the matter on behalf of respondent number 2.
Petitioner in the item number 21 here.
Huh? So, duta file আছে। Okay. What is your name? R. Deka.
Our declaration.
You are appearing for petitioner in item 21.
Yes, Lord.
His APS has been recently engaged in as the
And
counsel for the petitioner in criminal revision petition 94. And he also represents the respondent in item 20.
Yes, Lordship.
Respondent 20, respondent, sole respondent in item 20. He therefore seeks a short list. When?
After 2 weeks.
After 2 weeks. So let it go to July.
After summer break.
Let it be listed in. This is for hearing. Let it be listed for hearing in the month of August. Mr. Your name, please. P. Raman appears for the petitioner in item 20 and respondent in item 21.
My name may reflect in the item number 21.
The names of all counsels be reflected in the by the registry in the course list. Yes.
Item number 22.
Hello, once again.
Yes.
I will do the criminal petition number. For washing of the FIR as well as the subject. And the proceeding entirely. Whereby the technical cognizance has been taken against the petitioner under section 409, 406 and 420. Apparently, my lord, whatever the delegation is concerned, it appears to be, my lord, absolutely commercial. Just you're trying to give it a color of criminal offense, but there is absolutely no ingredient has been made out. If we go by the FIR and the subsequent charge sheet also. Now, there is a civil suit is also pending between the parties regarding the same amount of money. Now, I'll first like to draw lordship attention to the FIR. Page, my lord, 30. Respected sir, prayer for initiating investigation against the PK Engineering Consortium Private Limited. Ritu Tachi, Managing Director, so-and-so, Tachi Taras, Director, so-and-so, Director, email Tachi Tatu, Pradeep Kumar Roy, Vice President, Mr. K. Kanapati, Chief Financial Officer, etc. We are registered micro MSME. The accused in collusion in the capacity of the conspiracy with an under abatement from each other executed a formidable plan which dubious intent and finally culminating in cheating, breach of trust. As merchant and allied offences, the accused has committed crime by immense magnitude. The accused person through their man and agent approached us at our office on Chinmoy Complex, AP Road, Guwahati, under your PS, representing themselves as to be the big government contractor and malice in mind persuaded us to making supplies in spare parts in bulldozers, excavators, loaders, estate spare parts for the office at Model Village, Naharlagun, Arunachal Pradesh, and assured us to make payment within 20 days of the submission of the bills to be raised on monthly basis, and represented that they are honest, reputed, and authentic and defendable businessmen, and they have the financial ability to pay the state supplies. We have hesitantly to give the state space to this accused person, but by repeated approach of assertion, and the accused made us to supply them the state spares between February 2016. This is logically market. 16 to May 2020, amounting to rupees so unpaid till date. In part liquidation of the dues till 13/12/18, the accused on 6/1/19 gave us 12 number of checks, 11 checks of 25 lakh each, and one checks 14.22 to 48 dated 31/3/19 to the total sum of rupees 2 lakhs 2.89, all drawn at SBI Naharlagun Bazaar, but all of them got dishonored, against which the appropriate notice under 138 of the NIA was given to the accused. But on request and the assurance by the accused that the accused shall clear all our dues along the interest thereon, we did not file any proceedings against the accused under NIA, but out of total dues, the accused has voluntarily converted the sum of rupees 80 lakhs 97,000 to the loan account as principal for the period between principal. Now, the ulterior motive, the accused are cancelling such converted loan account for the period till 2020, and the principal dues of principal in the interest of principal around rupees 7 crore 97 lakh 40,840 rounded off is due to be payable by the accused to the period till August 2022. Now, from Lordship will find he admittedly in the FIR that the business transaction started from 2016 onwards, and thereon they have continued till 2000, the filing of the FIR 14 September 2020. Now, Lordship can see there was certain communication between the parties in between which are admitted the undisputed, uncontroverted document, page 57. Now, this is the notice has been issued to us by them on 17 November 2020. Client MS Hindustan Art Movers. Reference: supply of spare parts, bulldozers, excavators, loaders for your clients' office rentals. Now, we have been handed over by our client by email dated 20 with the instruction to write the above follows. In reply to our aforesaid letter, your aforesaid letter, the content of all our previous letter notices are set out herein that without prejudice to be say reference is made to our later dated transfer, which contains to reply to your later dated transfer as well as it may be read out in reply to your mail dated transfer. Our client never promised to make supply at reduced rate. All spare parts supplied to your client are now once and rates were finalized before the supply, and any discount and reduced rates or belief or delayed payment was never agreed upon. Every time your client makes false promises that they are going to make the payment soon. The total dues of our client is aiding therein the interest on total 7.52. Rounded the further interest in the status. Now, this is important, my lord, paragraph 4. Whatever payment your client has made, this is very important, is of all earlier bills raised between 2013 to 14.
the invoice number so and so 13/3/16 and the part of the invoice number so and so and the payment of the aforesaid amount of rupees 4,15,99 is against the subsequent supply for which invoices has been raised between 30/3/16 to 31/5/2020, and that has no payment has been made by your client in respect of the thereof till before 11/11/2020. So it appears, my lord, in between, since 2013, there was a transaction between the commercial transaction between those two parties, admittedly. And some amount also been raised, and amount also been paid to the parties. So it is the dispute arises in between, not at the initial stage of the agreement or when the parties has gone into.
But the checks issued bounced.
Check issue bounce, that's a separate issue, my lord. Check issue bounce, they could have filed a negotiable instrument act, does not create any offense under section 420. That is a 138 of the negotiable instrument act, that's a separate statute altogether.
This is not under 138.
It is not under 138, it is simply 420. Now the requirement of the 420, they are saying that the where from the 420 comes, what are the ingredients of 420? There may be, we may have failed to make some payments, dues to them out of the commercial transaction, but the sum amount admittedly has been paid to them from 2013 onwards. Though the FIR they say that the business started in 2016, but their own letter issued to us state that the transaction rather started from 2013 onwards. And there are some payments has been made to them also to the previous bills. So from the apparent that the transaction was going on from the very beginning, there is no dispute till 2016 onwards. All bills is paid. No doubt, subsequently we may fail to honor the bill. There may be different reasons, but whether it creates an offense under section 420, that is the first point your lordship has to decide. My humble submission before your lordship, that the failing of payment in a commercial dispute, ipso facto does not create an offense under section 420. Unless and until the inducement has to be there, a fraudulent inducement or initial reception as required under section 415 has been done by the petitioners. In this case, my lord, there is no abatement, there is no material.
You want to say that we are already engaged in a business, long-term relationship.
Long-term relation from 2013 onwards.
Therefore, there was no inducement to deceive.
There is no inducement, no initial reception. The business was going on. Subsequently, because of the various reasons, disputes may arise because of the price variation. That's a different issue. It's an absolutely commercial dispute. We may fail to provide, fail to honor the checks. We may fail to pay the money, but it does not create an offense under section 415. But the requirement of the 415, the primary requirement is the fraudulent inducement and initial deception. In the FIR, just quoting the minor, the section does not create an offense unless and until you must give the example how you have been cheated, or that there's a deception by us, but it's not that. It's some payment they have received, they're continuing the business from 2013 onwards. Apart from that, page 79, there's a mediation application. Lordship kindly see page 79.
Yes.
This is a mediation application. And the time period, Lordship kindly see. It is their document, my lord.
Yes.
They are saying that in the FIR, that from 2016 to 2022, they have 2020, they have not received any amount. Now Lordship can see the first column itself, the amount paid in the mediation from 1 to 2016 to 31/5/17, no payment has been made. Next one, 1/6/18 to 31/5/2020, 44,49,000 has been paid. Then again, 1/9/13 to 31/1/16, some payments also been made, has been paid. Total, this amount has been paid to them. This is their calculation. It is not my calculation.
Yes,
So from here also, we are, it is apparently that we are time to time paying something to them, and they have duly received the same. And we have also filed one affidavit in reply to their case, my lord. In that affidavit in reply, Lordship kindly see whatever you have detailed given the money which they have received
affidavit in reply to
by us.
their objections.
Yes, affidavit in reply. I'm sorry, my lord, there is no date in my petition. Affidavit in reply to the affidavit in opposition filed by the respondent number 2.
Yes.
I'm not going to the
8th of April.
ever page Lordship, stateway Lordship can give, go to the page 18 onwards. We have also annexed the checks. Now, page 18 Lordship can see there is a transaction date, value date, particulars. These are the all balance sheet. This is by TK Engineering Consortium Private Limited. This is the petitioner's company. Now Lordship kindly see 1, 2, 3, 4, 5, 6.
These are payments already made.
These are
Already
payments
released.
already made to them during the period. This is the period Lordship will find 4/4/16 to 4/4/18. Maybe a small amount. (4/4/16). And they are saying no single penny has been paid to them. Rather, maybe a very small amount, but this some amount has been paid to them.
Yes.
Again, we have also given the checks also, page 19 and 20.
Yes.
These are the check has been issued. Next, further Lordship kindly states page 28.
These are checks issued to whom? To the respondent.
Yes,
Page 18.
yes,
Okay.
to the respondent. Now, next is very important, page 28, my lord. This is also made to them, my lord. 34,202.36, my lord. And the date is 28 January 2018. 28 June 2018. Where they have disputed that they have not received, but this is the amount 34,202, my lord. Next page, there is one more check. Then 31, Lordship will one. Again, Lordship will find there is one more payment has been made. Page 31.
But these were these the checks which bounced?
No, these are the not.
These are in cash.
These are. These are it. And apart from these are checks, apart from those, these are the payments, e-pay order details. My lord, these are the through SBI Bank. Next one, page 32. Again, we have made payment. $3,54,590 only to the Hindustan Art Movers. This is also 21 December 2018. That time period. Next one also page 33. Again, we made a payment 2,90,590 only. This has been made payment. Then again, page 35. 15 February 2019. There is a 19,63,414 and 84 paisa only. So admittedly, these are the lots of money we have seen through account transfer has been made. All account transfer today. From that, I am not disputing that we have paid the entire amount. My case is different. In my case, it is an absolutely commercial dispute between the parties. There is absolutely no initial reception, no fraudulent inducement. Had it been an initial reception, then where is the question of payment? Where is the receipt? They claim, they have admitted that they have received the amount time to time. There may be dispute on the amount, but it does not create an offense on the 450, the cheating. Where is the deception of the initial part? They have to establish that fact matter.
Yes.
And the fraudulent inducement, where is the fraudulent inducement? From 2013 to 2022, the continuous business was going on. Where is the fraudulent inducement? Deception. Nothing. Payment was continuing, they received the payment. Subsequently, some dispute that may have arisen. But it does not create an offense of 420 or 406. And the 406 lordship, these are the parts we have purchased. This is our good. Moment we have purchased, paid the money. This is our money. So there is no question of any misappropriation of the parts because we have bought it. This is not the entrustment. Entrustment has to be without any consideration. This is an entrustment of the machineries with a consideration. We have paid for it, maybe not the full and final settlement.
Yes.
And neither, my lord, this is absolutely a commercial business transaction. I don't know where from they say the 409 has come. 409 does not come. Now, lordship, can you see? Now what happened, my lord? This is the FIR, this is the charge sheet also I'll place before your lordship. Page 64. Very small circuit, my lord. Page 65 is the content of the entire circuit, my lord, in the para 6. It's a translated type copy, my lord. The brief fact of the case is that on 13/10/20, my lordship can mark the date 13/10/20.
Page
65.
65. Yes.
The brief facts of the case is that on 13/10/20, one Dilip Bansal, Chinmay Complex 80 Road, Orolumukh, lodged a complaint that the Hindustan Art Movers supplied spare parts of this furniture engineering consortium Orolumukh today since 2014 for a total amount of 8,15,99,869 rupees. They had continuously gave the students of the payment of the outstanding amount, but they have failed to do so. During the course of investigation, prima facie case under section 406, 420 IPC has been made out. so. And Lordship knows the 420 and the 406, it does not go together. There is a judgment of our High Court. Either it has to be 420 or it has to be 406. But here is no question of 406 because we have purchased the entire goods. This is not the entrustment which is required under the 406 without any consideration. This is it. So, my lord, only remains the 420 here. And the 409, it does not come also because we are not the agent. And Lordship will find the cognizance order at page 72.
Yes.
Now, in this, before going to the cognizance order, just Lordship will point out one very important aspect in this case. Now, who are the accused, my lord? Here, Lordship will find. The first is the MD, petitioner number 1. Petitioner number 2 is the director. Petitioner number 3 is the director. 4 is the government employee, further of accused 1 and 2. 5 is the vice president. 6 is the chief financial officer
Oh.
of the company.
No.
Now, in the charge sheet, the company has not made an accused. Lordship kindly noted. Here, the charge sheet, only the 6th person has been where the petitioner before your lordship made an accused. Now, first and foremost, my lord, and here there is no question of 120B. No charge has been framed, no cognizance was taken, no investigation was done. The cognizance was also taken under section 406, 420, and 409 with a very small order without giving any reasons thereof how these petitioners are involved. What was the role, exact role played by all the petitioners who has been charged as an accused in this case. Lordship knows that in the criminal case, there is no question of any vicarious liability if the offence is committed by the company. Only thing is that if the person is liable, he is only liable for his own act and deeds in a criminal case under IPC. Had it been a case of 138, I can understand that he under section 141, managing director, and the official who runs day-to-day business of the company, they can also be charged as an accused if they are running the business. But here, this is an IPC offense. In the IPC offense, the act attributed to each and every one must be specific to take a cognizance. So parts basically admittedly were supplied to the company. So how these directors, managing director, chairman, the brothers of the so-and-so, the one officials, how they are responsible under the 420, whether they have gone, they have induced, or they have misappropriated. There's absolutely silence. Not a single whisper has been made against this person, that this person was responsible for committing an offense under section 420. I'll come to 420 later on. But first of all, in the FIR or in the charge sheet, there has to be some material, or while taking the cognizance, the magistrate must record his satisfaction that these person are issuing the summons because these person are specifically committed these offenses.
They're officers of the company.
Maybe, madam, but it does not mean it's an IPC offense. That's the difference.
They're
Officers of the company, lordship has to distinguish. This is an IPC offense. Had it been another offense in 138, yes. NIA 141, there is a specific provision. But in the IPC offenses, you cannot make liable only because they are officers. There may be hundreds of officers in the company. Just the company has maybe committed some offense.
Who placed the orders?
That they have to make out. It is not my duty,
It is not here.
not here, my lord. That is not, they are not specific that this is the man has committed deeds, he has induced me, he has fraudulently misappropriated, these two has connived with each other. There's not a silence, that is what I'm saying. Because vicariously liable, you cannot in a IPC offences, there cannot be any vicarious liability unless and until there's a 120B and specific allegation with the company. That company, so and so Mr. X is the company, and these are the officers who's working in the company, and they are connived with each other. This way, they have to give the example. Simply quoting the section and the ingredient of the section will not do. That they have connived, they have induced, they have fraudulently done so and so, that is not sufficient. The requirement of the law is that in an IPC offences, you must specifically make a case against each and every accused, how they are individually liable. How they are
Yes.
individually liable for the commission of the offence, if the offence is committed. If the offence is committed. My case is that here offence is even not committed. Because there is no 420 at all. For 420, where is the inducement? I'll come to that in a later stage, my lord. So here, simply making some of the officers, and there is not a single advertisement that these officers are looking day-to-day business of the company. Simply, the director cannot be liable. Even in NIA cases, 138, there may be 5-6 directors. Simply because they are holding the post of directors, you cannot make them liable under 141 unless there is a specific allotment that these directors are also liable for day-to-day business of the company.
They're entrusted.
They are interested. If that allotment is missing, then even the directors are not liable for the dishonor of the checks by the company. But this is a different statement. Here, we are
What-
dealing
what-
with simply IPC.
What has happened to the mediation?
My lord, mediation, no, mediation has failed. And there is a commercial, in the commercial court, there is a dispute is pending.
Is it?
Same relief,
Uh,
they have gone for the commercial court also. Against the same amount. Misuse. That's the commercial suit number 24, public 2022. Now, I'm only simply on whether the case has been made out under section 420. First of all, and this my second limb of argument is that the first of all, if you want to make us liable, you have to make the party, the accused, number one, has to be the company. Then only you can make us liable under 120B if there is a specific allegation against us also. Now, absolutely no specific allegation in the FIR against this person. The role played by each and every accused. Company is not made an accused. How they have initially decepted, where the transaction was going on from 13 to 2020. Where is the initial deception? They themselves admitted that the third part payments has been made. Maybe the period is different, but they are admitting for the same purpose from 2013. So where is the question of initial deception? Initial deception that I must fraudulently represent something. And subsequently they have found that yes, this is absolutely a fraudulent representation. And because of these fraudulent representation, we have parted our money, we have parted our property. But here, that's not the allegation. They have continued with us from 2013 till 2022 till the FIR, and they have admitted that there is a dispute regarding the price of the goods. So that's the all. So now where is the question of 420
No,
Now, I'll rely upon,
what is the status of the suit?
the status of the suit is now, WS has been filed. Issue has not been framed. But this criminal court and the civil proceeding always can run concurrently. Even the commercial dispute cases can run concurrently. I'm not disputing on that. They can, yes. If there is an at all criminal case has been, ingredient has been made up. There is no case, there are cases that there is a fraudulent document, fraudulent bill. This is not a case, simply that you have failed to make the payment outstanding dues, though we have committed to that. Is it a case of 420, my lord? If I borrow some money from my brother tomorrow, that I'll pay, make the payment tomorrow or some other time. If I fail to make the payment, is it a 420? But by false representing to my brother, if I take the money, then I fail to make the payment, then yes, 420 is there. But here, there is no question of any misrepresentation.
You're referring to some judgments?
Yes, definitely.
Yeah.
So, if you take me details, I'll go on that.
You can give us a list, we could have taken printouts.
No, I have prepared the bunch of judgment I am relying on. The first one, Lordship kindly note us, I'll not take you to the entire thing. The only I'll refer my paragraph and my contention. The first, my contention is the company has to make a part. That was my first argument. So this is the judgment 2015, 12 SCC 781. Sardar Kumar Sanghi versus Sangeeta Rani. This is the case, my lord. Here, my lord, Lordship will find paragraph 11 and 13.
Yes.
So this is the judgment that the company has to be in party first. And this is also regarding IPC offence. In a case in hand, may I read, madam?
Yes, please.
In a case in hand, as the complainant's initial statement would reflect, the allegations are against the company. The company has not been made a party, and therefore the allegations are restricted to the managing director. As we have noted earlier, the allegations are vague, and in fact, principally, the allegations are against the company. There is no specific allegation against the managing director. When the company has not been added as a party, no proceeding can be initiated against it, even where vicarious liability is fastened under the certain statute. It has been held by the three judges bench in so-and-so, Anita Hada, that so-and-so, in the context of negotiable instrument act. As I said before, in a special statute under 141, there's a special provision that the directors can be a vicariously liable if the company makes the bill under the checks. Statute. But here it's an IPC offense. Concept is totally different. There is no specific provision in the IPC to make vicariously liable the workers, unless and until there's a specific role has been attributed to each and every individual who has been charged for the offense. Now, paragraph 13. When the company has not been added as an accused, such an order could not have been passed. We have said so far, the sake of completeness, in the ultimate analysis, we are of the considered opinion that the High Court should have been well advised to quash the criminal proceeding initiated against the appellant, and the having been not been done, the order is sensitively vulnerable, and accordingly we set aside the same and quash the criminal proceeding initiated by the respondent against the appellant. So that was my first contention. Here, company is not made an accused. Only some of the employees been made an accused without any specific role attributed to them. Now, next one also, Lordship, 2019 17 SCC page 193.
On the same lines, on
Same.
the same ground.
Same. Paragraph 19 and 21, Lordship kindly mark it.
Yes.
The liability of the directors, the controlling authorities of a company in a corporate criminal liability is elaborately considered by this court in Sunil Bharti Mittal. In the aforesaid case, while considering the circumstances when the director 193. Sunil, in the aforesaid case, while considering the circumstances when the director or the person in charge of the affairs of the company can also be prosecuted when the company is an accused person. This court has held a corporate entity is an artificial person which acts through its officers. The director, managing director, chairman, etc. If such a company commits an offense involving mens rea, it would be normally be the intent and action of the individual who would act on behalf of the company. At the same time, it is observed that it is the cardinal principle of criminal jurisprudence that there is no vicarious liability, as I say, unless the statute specifically provides for it. In IPC, there is no vicarious liability. It is further held that this code, an individual who has perpetrated is a commission of an offense on behalf of the company can be made and accused along with the company, Lordship kindly mark it, along with the company, if there is a sufficient evidence on his active role coupled with the criminal intent. So here, that is absolutely absurd. There's no allegation against any of the individual who has been made and accused in this case. Not a single whisper, my lord. How they have been, what role they have been playing. The further it is also held that an individual can be implicated in those cases where statutory regime itself attracts the doctrine of vicarious liability by specifically incorporating such a provision. That is what I am saying in 138 under section 141 of the NI Act. Now, Lordship kindly turn to my next judgment 2021 SCC online Supreme Court 806.
Also on the same lines.
No, my lord. This is
Person with.
complaint or in the FIR, there has to be specific allegation, paragraph 23, Lordship kindly mark.
23 or 24?
My lord,
24.
not 23 also.
Okay.
24 is, as I said, that the Sunil Bharti Mittal's case has been referred. 23, my lord, the except at the above allegation, there is one line only. There is no further allegation in the complaint. It has not been even in a case on behalf of the complainant that at the time when the compound wall was demolished, here the compound wall was demolished and the trees were cut, the accused number 2 to 5 and 7 to 8 were present. Except the ball statement that the accused number 2 to 5 and 7 and 8 have conspired with the common intention to lay the pipeline within the scheduled properties belonging to the complainant without any lawful authority, the right whatsoever, and in furtherance of they have committed the trespass into the schedule of properties of the complainant and demolished the compound wall. There are no other allegation that at the time they were present. Accused number 2 to 5 and 7 to 8 are stationed at Hyderabad. There are no further allegation that the command of 8 to 5, 7 to 8, the demolition of the compound walls has been taken place. All of them are arraigned as an accused, as chairman, managing director, deputy general manager, civil engineering planner, executive chairman, executive director, respectively. Therefore, as such, in absence of any specific allegation and a specific role attributed to them,
Yes.
the learned magistrate was not justified in issuing process against the accused number 1 to 8 for the offence punishable under section 427, 447, 506, 120B. This is section 34 of the Act. Now, Lordship, can you see paragraph 26? This is a famous case referred in the Pepsi Court, my lord. Paragraph 26 and 27. This is the role that is the magistrate has to pass while issuing the process. As observed by this court in the case of Pepsi Court Limited, the Special Judicial Magistrate 1999 5 STC, and even thereafter in Katana of decision, the summoning of an accused in a criminal case is a serious matter. The criminal law cannot be set into motion as a matter of course. In paragraph 28, the Pepsi Court Limited, it is observed that the held as under. The summoning of an accused in a criminal case is a serious matter. The criminal law cannot be set into motion as a matter of course. It is not the complainant has to bring only two witnesses to support the allegation in the complaint to have the criminal law set in motion. In order, the order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. He has to examine the nature of the allegation made in the complaint and the evidence both oral and the documentary in support of thereof, and would that be sufficient for the complainant to succeed to bring the charge home to the accused. So it is the role of the, now in the cognizance order, Lordship will find there is a one-line order that cognizance has been taken under section so and so against accused by filing prima facie case. Now paragraph 27, as held by in this court in the India Infoline Limited, so in the issuing summoning, the learned magistrate has to record his satisfaction about a prima facie case against the accused, who are managing director of the company, secretary, directors of the company, role played by them in respective capacity, which is a sine qua non for the initiation criminal proceeding against them. Looking to the avertments and the allegation in the complaint, there is no specific allegation and no avertment with respect of the role played by them in the capacity of the chairman, managing director, executive director, deputy general manager, planner, and executor. Merely because they are chairman, managing director, executive, and the deputy general manager, planner, so and so, without any specific role attributed and the role played by them in the capacity, they cannot be added as an accused. More particularly, they cannot be held vicariously liable for the offense committed by accused number 1 and 6.
Yes.
So, cognizance order, Lordship will find no specific role has been attributed to any of the accused who has been charged here for alleged offenses. Absolutely silent, learned magistrate, how he has applied his mind, what material he has found against this been charged accused before your Lordship. Now, next one, my Lordship will find, this is 2013 4 SCC 505, paragraph 19, my lord.
2000.
2013 4 SCC 505, paragraph
Yes.
19 will do.
Yes.
In order to issue summons, the learned magistrate has not recorded his satisfaction about the prima facie case against the respondent 2 to 7 and the role played by them in capacity of the managing director, the company secretary or director, which is the sine qua non for the initiating criminal proceeding against the state. So and so and so. So there is no specific allegation with regard to the role played by them. Apart from the fact that the complaint then this is the Thermex judgment, that the second part, point 39. Apart from the fact that the complainant lacks necessary ingredients of the section 405, 406, 420, read with section 34 IPC, it is to be noted that concept of vicarious liability is unknown to the criminal law. As observed in earlier, there is no specific allegation made against any person, but the members of the board and the senior executive are joined as a person looking after management and the business of the appellant company. So accordingly, this has been quashed. Again, the same mala specific role mala 2008 5 SCC 668 mala paragraph 13. Only Lordship can go to the head note truth. The vicarious liability B mala.
Yes.
Directors for the charges level against the company, untenability, absence of requisite allegation with regard to the correct statutory provision held that the penal code does not contain any provisions of attaching vicarious liability on the part of the managing director or the directors of the company when the accused is the company. The magistrate should have examined whether the complaint made by directors are personally liable. Paragraph 13.
Yes,
Where a jurisdiction is exercised on a complaint petition filed by the terms of section 156(3), that is, my love, after 156, it comes to a FIR, or section 200, that is, my love, complaint. 156 is the FIR. Code of Criminal Proceeding. The magistrate is required to apply his mind. The penal code does not contain any provision for attaching vicarious liability on the part of the managing director or the directors of the company when the accused is the company. The learned magistrate failed to pose unto himself the correct question as to whether the complainant petition, even if a given face value and taken into be correct, it is entirely would lead to a conclusion that the respondent herein were personally liable for any offence. The bank is a body corporate. Vicarious liability of the managing director would arise provided any provision exists in the behalf of the statute. The statutes indisputably must contain provision fixing such vicarious liability. Even for the said purpose, it is obligatory on the part of the complainant to make requisite allegation which should attract the provisions of constituting a vicarious liability. Now I'm coming back to my lord 420, my lord. As I said, my lord, Lordship knows before going to Lordship kindly, the 415 is the provisions, my lord. 420 only the penal provisions. In the 415, the requirement is that there has to be a fraudulent inducement and initial deception. The cheating.
yes,
What constitutes cheating, my lord? Whoever
yes,
by deceiving any person fraudulently or dishonestly induces the person so deceived to deliver any property to any person or to consent that any person shall retain any property or intentionally induces the person to deceive to do or to omit to do anything which he would not do or omit if you were not so deceived, and such act or omission causes or is likely to cause damages, harm to the person in the body, mind, reputation, or the property is the said to cheat. So this is the requirement is that the fraudulent or dishonest inducement or deceiving at the initial time, from the initial deception. That's the requirement of the 420. Here, what is the initial deception, madam? We have simply asked for supply of machine. Accordingly, they have supplied the machine. We have made the part payments from 2013 to 2020. They have rather concealed the fact they have received the part payments in the FIR as well as after the investigation in the charge sheet. They are totally silent regarding the receipt of the payment. Why? Just to make out a case under section 420. But their own admission, apart from my document, incontroverted document, my lord, their own admission, they say they have received some amount. Even maybe 1 rupee. The amount is not a thing. The requirement is that
intention,
whether there's an initial deception is not. Intention. So now Lordship kindly see, this is 2015 8 SCC 293 paragraph 12. This is the famous case of Vasa Holding Private Limited, my lord, and paragraph 12 will answer the all queries. From the decision cited the appellant, the settled proposition of law is that every breach of contract would not give rise to an offense of cheating, and only in those cases breach of contract would amount to cheating where there was any deception played by the at very inception. That is very important. at very inception. If the intention to cheat has developed later on, the same cannot be amount to cheating. In other words, for the purpose of constituting an offense of cheating, the complainant is required to show that the accused has fraudulent and dishonest intention at the time of making the promise or representation. Even in a case where the allegations are made in regard to failure on part of the accused to keep his promise, in absence of a culpable intention at the time of making initial promise, being absent, no offense under section 420 of Penal Code can be said to have been made out. It is squarely covers my case. Here, there's a continuous business transaction from 2013, admittedly, part payment they have received. There's no question of any initial fraudulent inducement on part. There's no awardment. How they have been, there is anything, if there is anything regarding the fraudulent or inducement, fraudulent inducement. Absolutely nothing. Rather, it is contrary from the record. The next one, my lord, same, the recent judgment, the same line, my lord, 2023 SCC 240, my lord, paragraph from 7.2 to 8.2, my lord. This is an order against one of the Guwahati High Court did not quash the FIR. Then the appellant went to the Supreme Court. Again, my lord, same Arunachal Pradesh. The 7.2, my lord, Vesa holding, as I already pointed out. Then the 7.2 is the Hiralal Harilal Bhagwati. The paragraph 20 has been quoted. It is settled law by the catena of decision that the establishing the offense of cheating, the complainant is required to show that the accused has fraudulently or dishonestly intention at the time of making the promise or representation. Then again, 7.4. It is observed that held by this court that one of the ingredients of cheating is the existence of fraudulent and dishonest intention of making initial promise or existence thereof from the very beginning of the formation of the contract. It is further observed that held that it is one thing to say that the case has been made out for trial and as such criminal proceeding should not be quashed. But it is another thing to say that a person should undergo a criminal trial despite the fact that no case has been made out at all. The Supreme Court said, on the basis of the anticipatory evidence, we cannot allow the court to proceed. That tomorrow, during the trial, that was the observation of the Guwahati High Court, that the criminal trial, there may be some material. That's not the law. Law is that on the day, it has to be there, exception from the very beginning. So there's one judgment, Lordship knows, a very famous judgment of 1971, our ALR, DM Sain's judgment, on the basis of anticipatory evidence or hypothetical situation that if tomorrow in the criminal trial something may arise. That's not the proposition of the correct law. If the prima facie no case has been made out, the duty of the court that it should be quashed and it is so. The paragraph 7.6, the Joseph Salvaraj, it is observed that held by the court when the dispute between the parties constitutes only a civil wrong and not a criminal wrong, the court would not be permitted a person to be harassed, although no case has for taking cognizance of the offense has been made out. That's what I am. That's what I am. Paragraph 7.7, the Indra Mohan Goswami versus State of Uttaranchal. It is observed that the held by the court that the court must ensure that the criminal prosecution is not used as an instrument to harassment or for seeking private vendetta or with the ulterior motive to pressurize the accused. That is exactly what is been done here, my lord. They have initiated the civil proceeding. They have gone to the commercial court. Then again, they have filed an FIR just to pressurize us to make the payment. 8.1, my lord, let's observe wherein the charge sheet has been filed against the appellants for the offence under section 420 read with section 120B IPC. However, it is required to be noted that there is no specific allegations and abatement in the FIR, and this is Lordship, this is squarely covers my case. However, it is required to be noted that there are no specific allegations and abatement in the FIR and or even in the charge sheet that fraudulent and dishonest intention of the accused was from the very beginning of the transaction.
Was there any agreement between both parties?
No, actually. The agreement always can be, my lordship, there are two ways, even the oral agreement. also can-
Any written agreement
No.
that you will purchase that many items?
No,
or-
that's not the, only the supply, then the payments has been made,
All right.
but it is an admitted fact. And that's why they are going to the commercial court file. Lordship, I think we should continue up to our. Now, I'm relying on the late judgment. That is 2022 SCC outline. Supreme Court 1061. By Honorable Chief Justice of India. And yes, Gopalna, my lord. Justice. This is regarding also 420 and 405. Para 16, 17, my lord.
Yes.
This is 60 and in Hidayaranjan Prasad Verma, of the state of Bihar, two judges bench of the court interpreted the 415 and 420 of the RPC to hold that the fraudulent and dishonest intention is a precondition of the constitutional offense of cheating. The 11 extract from the judgment is done. On reading of the section, it manifests that the definition thereof sets for two separate classes of act which person deceit may be induced to do. In the first case, he may be induced fraudulently when dishonestly deliver any property to any person. The second class, the act set forth in the section is the doing or omitting to do anything which the person deceived would not to do or omit to do if he were not so deceived. In the first class of cases, the inducing must be the fraudulent or dishonest. In the second type of case, the inducing must be intentional but not fraudulent or dishonest. In determining the question, it has to be kept in mind the distinction between the mere breach of contract and the offense of cheating is a fine one. It depends upon the intention of the accused at the time of inducement, which may be judged by his subsequent conduct, but for this subsequent conduct, it's not sole test. Mere breach of contract cannot give rise to a criminal prosecution for the cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction. That is at the time when the offense is stated to have been committed. Therefore, it is the intention which is the twist of the offense. To hold the person guilty of the cheating, it is necessary to show that he had fraudulent or dishonest intention at the time of making the promise. From this, mere failure to keep up the promise subsequently, such a culpable intention right at the beginning. That is, when he made the promise cannot be presumed. But it is the presumption also not available.
420 and 405.
405. 17 also same. Then 21, that you can see regarding the 405. The offense of criminal breach of trust contains
Entrustment of property,
entrustment of the.
which is not there
Yes.
in your case.
Yes. In my case, we have
You had
purchased.
purchased it. So there was no, you are not an agent.
Yes. We have purchased, we are not an agent. Property which has domain over the property and the person entrusted dishonest misappropriation or converts it to own use of the property to be determined to the person to entrust. The entrustment also be described in So here, there's no entrustment at all. We are not the, simply we have purchased it. So, in the consideration, we have purchased it, so it's not the entrustment. Next term, my lord. 2023, 3 SCT 423, my lord. Here, the High Court has dismissed, this subsequently the Supreme Court has allowed. There is a regarding a coach bill, madam. The allegation is that there is also a commercial dispute, and during the dispute, the allegation is that the coach bill has been raised by the company. So, paragraph 7, madam. In our case also, there is a commercial transaction. Paragraph 7, madam, the private company is finally equivalent to complainant except the factor of commercial relationship between the parties. Here also, madam, it's a admitted fact there is a commercial transaction between the parties. Then paragraph 17 also the 405 value, and the 18 is 420 value. The similar line of conduct. In the 17 also, in the middle part, there is a force bill has been issued by the petitioners. There is a commercial dispute. Here, just I'm reading, the mere long demand of claim would not meet the conditions specified in 405 in absence of evidence to the established entrustment and reservation application. Again, 18 and the 420. Now, most important part of this reference is the paragraph 31. Here also, as I have said before, the guided magistrate while issuing the process matter, he has not discussed the specific role played by the accused, and he has neither discussed how the 420 or 405 has been made out. 31 says the summoning order is to be passed when the complainant discloses the offence, and when there is a material that support and constitutes essential ingredient of the offence. It will not be passed lightly or as a matter of course. When the violation of the law alleged is clearly debatable and doubtful, either on account of the paucity or lack of clarity of facts, or on application of law to the facts. The magistrate must ensure the clarification of the ambiguities, the summoning without appreciation of the legal provision and their application to the facts may result in an innocent being summoned to stand the prosecution trial. The initiation of the prosecution or summoning of the accused to stand the trial, apart from monetary law, sacrifice the time and effort to prepare the defense, also cause humiliation and disrepute to the society, and a result of anxiety and uncertain time. And accordingly, paragraph 33 and 34. The order sheet of the trial court enclosed the appellate reveals that the notwithstanding that the summoning order was limited to the unnamed manager and the chief manager's so additional chief judicial magistrate had deemed it appropriate to issue non-billable warrant. Non-billable warrant was not issued in the name of any person, but by the designation against the chief manager's so. It was also one of the reasons that he has prompted the appellant to file an petition under section 482 of the code. We must also observe that the High Court, while dismissing the petition filed under section 482 of the code, failed to take the due notice of the criminal proceeding should not be allowed to initiate when it manifests that these proceedings have been initiated with ulterior motive and reckoning the vengeance, which is viewed to spite the opposite side due to private and political grudge. So, here, as I said, the magistrate is absolutely silent how the accused are responsible, madam. And he, I will not go into this 2023, that's it, the online is 19, paragraph 6, 17, 70. Lordship kindly go to Only six I'll just read, my lord. Paragraph 6, Paramjit Batra has a state of Uttarakhand, my lord. Here, while exercising jurisdiction under section 482 of the Code of High Court, has to be cautious. This power is to be used sparingly and only to purpose of preventing the abuse of the process of any court or otherwise to secure and justice. Whether a complaint discusses a criminal offence or not depends upon the nature of the facts alleged therein. Whether the essential ingredients of the criminal offence are present or not has to be judged by the High Court. The complaint disclosing civil transaction may also have a criminal texture. But the High Court must see whether the dispute which is essentially a civil nature is given a clock of criminal offence. In such situation, if a civil remedy is available and is in fact adopted as has happened in this case, similar to my case, my lord. In this case, the High Court should not hesitate to quash the criminal proceeding to prevent the abuse of process. So here also, my lord. 1617 lordship can be seen that the Nikalika
Referred.
16 and 17 lordship will go to where perusal. 16 also says when the bare perusal of the allegation and the evicted abstract meaning as advertisement hearing would reveal that the allegations are vague and they did not carry an essential ingredient to consider as a.
Yes.
17 also said, the aforesaid circumstances coupled with the fact in the respect of the issue involved, which is a civil nature, and the respondent has already approached the jurisdiction of the civil court by instituting a civil suit, it is pending. There cannot be no doubt with respect to the facts of the attempt on the part of the respondent is to use the criminal proceeding as weapon to harassment against the applicants. Now, this is one of the most important judgment, my lord.
Yes.
It's a law, old judgment, but very important. 2009 KNFCC 184. Paragraph 9 is a very short judgment, but very effective one. Paragraph 9. In order to judge a proper complaint, mere mention of section and language of those sections is not be all and end of all the matter. Paragraph. Here in the FIR, they have simply quoted the section. The language of the section has just been adopted in the FIR.
Yes.
The Supreme Court says what is required to be brought to the notice of the court is to particulars of the offence committed by each and every accused and the role played by each and every accused committing of that offence. That's the my case. They are simply saying there is a fraudulent inducement, fraudulently they have been deceived. That is not the correct proposition. Correct proposition is that they have to avoid in the FIR or complaint what is the exact role played by each and every individual who has been charged for alleged offence. They are absolutely silent in the FIR. In the charge sheet also, it is silent which role has been played by which accused. And the cognizance order also the same. Mechanically, he has passed it. Absolutely silent, the role of the each and every individual accused. The cane also says when we see the complaint and the complaint is deadly vague, it does not show as to which accused has committed what offence and what is the exact role played by his appellant in commission of the offence. There will be said something against the Rajesh as the allegation are made against him more precisely, but he is no more and he is already expired. Under such circumstances, it would be an abuse of the process of law to allow the prosecution to continue against the aged parents and Rajesh. It was the case of dowry demand and 498. Regarding parents, there is a vague and so simply, madam, just the mentioning the ingredient of the section will not do. They have to particularly state what is the how the offence has been committed. Now, there are two judgments, my lord, I will not bother you. There is a recent two judgment by our High Court. That one is criminal petition 3 of 2022, my lord, and one is criminal petition 4 of 2019. In one case, my lord, the company was not in party, my lord. It is only the branch manager of the federal bank and the other directors were made a party. Here also, paragraph 7 and 9, 8 and 9 lordship can party. And it's similar, my lord, there is no apartment as regard to the role played by the each and every accused. And the cases instituted on IPC, my lord, whether the vicariously person can be made liable without any specific delegation. Similarly, on the same footing, there is one more judgment of the state Kohima bench, my lord, recently judgment. Where the 420, 406 has been discussed elaborately in those two cases. And accordingly, both the petition being allowed and the proceeding has been quashed. And lordship kindly see the page 72 of my petition, the order passed by the magistrate concerned. Case record received, the transfer and disposal, peruse the case record, cognizance of the offence of 406, 420, 409, the IPC is taken against the accused person, namely so and so, so and so, so and so, so and so, on perusal of material available on the file. Issue summoning the accused person. That's all. How they are responsible, how they have committed the offence, whether the offence has at all been committed under 420 or 406, no discussion.
Yes.
And the lordship also can see here, company is not an accused, no someone has been issued to the company.
Yes.
So, on this ground, madam, it's an absolutely commercial dispute of a civil nature, madam. There's no ingredient of 420, 406 either. There's no mention of the road. Company is not a party. There's no question of vicarious liability. They have accepted that there is a transaction from 2013 in their legal notice. Also in their document, which is uncontroverted document, which is they have used in the commercial code, where they have accepted the acceptance of the some amount of money during the period, rather they have suppressed. And when they have come for the equity matter, naturally, they have to come with a clean hands. But here, as lordship has seen, they are totally silent about the payment, is silent about the transaction which is going from 2013. Rather, they are trying to make out a case of from 2016 onwards that we have promised, we have failed to make the payment, we have delayed, we have issued checks, but they have also silent about the fact that the some of these checks have been honored, some of the payment through RTGS, through bank has been accepted. And they are also silent that the transaction rather than from 2013 in the FIR is going on. But if their own notice and the other uncontroverted document before the commercial courts, it's clear that the payment has been made, some payment, and the process has started from 2013 onwards, not from 2016, as they have alleged. And they are also silent about that the civil suit and these are also pending. So it's apparent that just to try to give a color of a criminal nature and just to presurize these person were absolutely there's no ingredients has been attributed. They have been brought in as an accused. So my humble submission, madam, is my petition should be allowed and the FIR and subsequent charge sheet and the order of taking cognizance should be set aside.
Okay.
That's all.
Yes, Mr. Shan.
May it lordships. Before I enter into the control submission of my lord affair, there was going to come to page 11 of my ABDB notification, my lord, page Annex A.
Yes,
There once violated by way of criminal evidence petition number 94/2021, a full dispute violation. And if no reason, no ground, they withdrawn this case. On the request of Mr. S. K. Deori and the counsel for the petitioners, this matter is disposed of on withdrawal. No liberty was taken. Now I will come to matter annex the matter, it is FIR part. FIR is. FIR matter, page 30.
Page
September 2020.
38 of the writ petition. I'm
Yes.
sorry, criminal petition.
Yes,
Okay.
respected sir.
Yes,
Pray for initiating investigation against MSTK Engineering Consortium Private Limited. Company is made the party matter. So all the three reasons are not applicable.
kindly come again.
Hello?
Please come again. Please repeat.
Pray for initiating investigation against MS.
You're reading from page 38,
30,
30.
the fire.
Yes.
This subject matter. Prayer for initiating investigation against MSTK Engineering Consortium Private Limited. Petitions to Mr. Rashid Ali, Managing Director, and all those issues with the company. Now, the transaction matter, let me first, before going to the petition matter, whatever 13 to 14 and up to 15. Whatever material supplied, they will pass transaction matter, there is no dispute out there. The dispute started matter 2016-17. In fact, I am annexed at the annex B of my counter matter. The total amount due. Thereafter, not a single farm was paid. And 2019, 31st of January, March, he issued 12 number checks on the same day. PDC. And on the basis, materials were supplied again. Without that, those checks will come. Honor. They did not honor. Not one check also. They are not in that matter. What my learned friend is showing for me the every reply.
But you did not proceed under NI Act.
No, the notice was issued the matter within procedure. I put the procedure or NI option is there. Now I have to kindly come to their immediate matter who is there, then it's few of the checks matter. Those checks were matter issued. Matter when we stopped supplying materials after the payment of about 4 crore was due, they repay single farthing. The dispute is not 13-14. Dispute is 16-17 onwards. They would receive a check, those that we are going to pay. Suppose that the check, materials would be taken, then checks will bounce. And the text he has shown in his video manner, that is also kindly come.
You are saying disputes are from 1670,
Yes.
not from the initiation.
No, that part is clear, man. That we are doing that. We only cited that there was a business going on with the party from 13 or 14 onwards. There is another thing.
Yes.
My lord, now we are kind of come to their checks. Annex 24, two of the. In counter matter page 23 onwards. 23 of the reply manner.
Yes,
Again, 4 crore due manner. When we stop total supply. Because this company was executing works under the NSAI in North Bank manner. That from case to onwards, particularly Gopur area. Now there is because of the fraud played with the government of India also, his license will be cancelled, the contract will be cancelled. So against the 4 crore, what is the check amount manner? In 2017, 5 lakh.
5 lakhs.
5 lakh. Because what happened, when you stop supplying, they would come with the check, then my lord, here's the check, it's not cross check. Immediate investment, that take the material. Second also same. So I come to page 24. What is the amount? 22 lakhs.
No, so therefore, there you accept that there was a business relationship.
Yes.
You were supplying, they were purchasing, some payments were made,
No,
some were not made.
no. When you stop payment, my supplying from 2017, then they would come.
Is this on the basis of a contract or is it upfront?
No, there was no repeat contract itself. Because they would come, they would give the check, which would be immediately encashed. Because it is not cross check, it was to be currency. So they would pay, give this check and
So therefore, there was technically no entrustment.
no, there, not about this matter, there is this about this day-to-day transaction.
So there was no entrustment.
Suppose I would go with the gas and pay the gas and take the money. It is like that. Sure.
So they are not your agents. They are not your agents or a branch.
So far, this is concerned, I come to that department. Now he wants to show matter further transaction of 16, 17 to 20. These are the loan payments that they had paid time to time. This is not that. It is like paying by cash and taking the material. When you stop, total we stop supplying them from 17 onward. But there is no other alternative. So they will come with the check, sometimes with cash also. Ready? Again, next matter. Page 20 is kindly see.
No, but if just a passing thought, they had purchased, they had ordered for some materials you had supplied, they did not pay earlier.
Yes.
Earlier. So in 16, 17, when you stopped supplying, they came with the pay checks for goods.
It's not connected with the transaction.
Ah,
That old transaction, the new transaction is even there.
okay.
Then whatever matter, they have no other alternative to get the materials. The material we supply comes from Calcutta companies there. And we have got a branch here. For where would supply? Not to them to others also. So matter there, what they being helpless, they will come. Then that's why I see to come to page 26. What is the amount of the purchase made on that day?
Page 26
Yes.
is a check.
Say 12,230. This is not the repayment for the those dues who they will cheated us. 12,000. Then next one is
So essentially what you're saying is that these checks pertain to certain purchases which are subsequent and not connected to the earlier.
no. No. So the initiation, the
No,
inception,
No means
it is not a check for those transactions.
it is not a check for those transactions.
Yes,
So that is what I'm saying.
yes.
Your contention is that the earlier transactions they refused to pay.
They used to pay, they didn't pay a single party money.
Subsequently, they came, paid money,
Yes,
you sold the goods.
yes. But earlier transaction remain, and this is not, they have no connection with the earlier transaction. When that relates to the cheating at the very inception, taking the material for 4 crore and then sitting silent, in spite of notice also, and why to issue for 12 checks and bounce all. If they had the intention to pay, and there was no element of the matter cheating at the inception. They would issue the check, then matter showing that is, we are issuing the check, you honor it, but the check never honor. One to check might have bounced for some reason, not all to serially.
Yes,
No matter there was an element of or cheating at the very inception. The intended risk will issue go this way. And this may also be a matter technique. That yes, we are issuing this check, getting the material immediately, same day, and we would show this to be continued transaction, so that the element of 420 would not come. Then next check, page 28, how much? 34,202. Which one was that? So you matter the first check. Then another 15,000. Then another 1,20,000.
all right, some payments they have released, which according to you does not pertain to 2013.
That part is totally separate.
Again, I have to ask you that no means what? Yes.
That part is not connected with this one.
So
And this is not connected with that. That is
Correct.
my no.
Correct.
Yes.
So your answer essence is yes, that this payment is not connected to 2013.
Yes. So, madam, my humble submission was there was clear intention to cheat of the amount of 4 crores, now calculated by 7 crores. So, madam, and what my learned friends argued, madam, taking, as if it is in the trial court he is arguing, it's not that. Because the law should certainly not go. What is the prime immigrants for 482? There must be primary case. It is not for the FIR or lawsuit can see case 30 again.
Hmm.
It is detailed out. 4,15,99,869 from 2016 to May 2020. This amount, and they issued the check of 2 crores 89,000 something, all bounced. Against the 138 notice are given, but we didn't proceed that way. Then by this FIR, and this commercial suit was filed later on, not earlier. So that
So later on, but pertaining to which,
no, this way, because we have to recover the amount.
the 2013.
No, I'm not talking about 2013, my lord. 2013, 14 is not, no connection here. That earlier part is clear, wouldn't be given. When the press started taking material in 2016, when he got the contact from NSI. From 2016 onwards, he started getting some contract from the NSI for 4 lane expansion. That part I take. And I don't know whether he used this material or not. Otherwise, while the government could cancel his enter contract.
No. You tell us the debt, the receivable, the amount which you are required to receive from him pertains to which particular year?
I've said in the FIR from 2016 to 2020.
So the earlier payment, what was the relationship? What was the status in respect of
Which one?
2013 onwards?
No, 13 onwards, there is no.
There is no dispute.
That part is clear. We have not clear anything. 2013.
Okay,
2016.
all right.
2016 to 20.
Hmm.
After 14, that's clear. We don't make. We will not make any. You have to take measures from 2013-14. Then in between 50 days come. But there is no contact. 16 onwards, again he started taking contract. Then he started taking like this.
Okay.
But from then, no payment. amount into total 4 crore. Lakhs, my lord. Until that, there is due. Not a single partnership. Therefore, it's issued to Huri Master. In fact, the very purpose of issue of the check was to Huri us that yes, they are being issued, payment follows, you should go on supplying to material. That again, clear speaking. That is my case. Now, my lord,
So if, I'm just trying to understand, if it has to be cheating,
Yes.
is there a concept of part cheating?
but there is, I am not talking about partying. Partying means from 2016 onwards, when the material started going to them, they didn't make any payment. Otherwise, they would
These
have-
these checks,
Hmm.
which you have referred to, these were not cleared. This page number 26 onward.
Those are, my lord, for the payment made hand to hand. They are not for the clearance of the dues for 2016 to 20. There are 3 parts. One, 13, 14, there is gone.
So these are with regard to individual purchases.
Individual purchase. Yet employee will come, when we refuse to supply further on credit, they will give a check, which could be encashed immediately. It was not a cross check. Then they take the material, but not the payment of 16 to 20. That is what my say.
Okay.
Otherwise, my lord, they would not have given the 12 check to bounce. If they are a clear mind. The cheating started in the very inception of the transaction. 2016.
Yes.
Now, my lord, regarding the company part I have shown, my lord, those two decisions are not available. Even those last decisions of the High Court, those are not applicable.
It is not.
Applicable.
Why?
The company is already, it is in the FIR.
Hmm.
We already first accused the company. And my lord, the inception at the stage of cheating. I have already explained the two lawsuits clearly. Now, my lord, come the twin proceedings.
No, before that you have to say
Yes,
his contention is, number one, there was no specific allegations against the company and specific allegations against the officers against whom the court has taken cognizance, issued
my
summons.
lord. My lord, in case 30 lawsuits against them. And my lord, these are the supply. So the employees would come and take the materials on behalf of the company, the director, manager, and everybody. It is supply.
But there has to be some allegations.
Allegation paragraph 2, my lord.
Hmm. There are two of.
FIR, case 30.
Okay.
In fact, yes, paragraph 2. Accused persons through their man and agent approach us at our office said in my complex 80 road Guwahati, so under your PS, representing themselves to be a big government contractor and with values in mind, persuaded us for making supply of spare parts of bulldozers, excavators, and loaders. Then spare parts for their office at modern village Naharibur, Andhra Pradesh, and assured us to make payment within 20 days of submission of bills to be raised on monthly basis, and represented that they are honest, reputed, authentic, and dependable businessmen, and they have the financial ability of payment for the state supply.
Hmm. Yes,
And those persons are already in the subject matter, where company is the party, then their responsible director, managing director. and all.
yes.
They say the distance to individual loss, right? No.
You can give us a list. You don't have to take out prints. This is a request to the bar. We have the facilities. If you give us a list of the judgments, they'll take it out. It will save the trouble. Yes. Yes, yes. No, we are thankful that you have taken printouts. What you're saying is that.
First judgment is minor regarding the criminal proceedings running. The judgment is as old as of 1954. Minor.
Yes.
Constitutional bench decision.
So there is no quarrel on that between proceedings, civil and criminal.
Yes, civil and criminal, but we should get precedence in December. We should be decided first. We should get in effect. This is the issue. We have to file matter because it's 2020 onwards, otherwise the time limit for 3 years should expire. We have to file in 2022. There are 14 matter. We were informed at the hearing that two further sets of proceedings arising on the same facts are now pending against the appellants. One is two civil suits for damages for wrongful confinement. The other is two criminal prosecution under Section 344 of the Indian Penal Code for wrongful confinement. One against each other is sub-inspector. It was said that simultaneous prosecution of these matters will embarrass the accused. But after the hearing of the appeal, we received information that two criminal prosecutions have been proved with liberty to file press complaint when the papers are ready. If the High Court records were not available on the application of the accused, if these prosecutions are not pending at the moment, the objection regarding them does not arise. But we can see that the simultaneous prosecution of the present criminal proceeding, out of which this appeal arises, and the civil suit will embarrass the accused. We have therefore to determine which should be taken. Yes, between the civil and the criminal proceedings, we are of the opinion that the criminal matter should be given the precedent. There is some differences of opinion at the High Courts of India on this point. No hard and fast rule can be laid down, but we do not consider that the possibility of the conflicting decisions in the civil and criminal courts is a relevant consideration. The law emphasizes such an eventuality when it expressly refrains from making the decision of one court binding on the other, or even relevant, except for certain limited purposes, such as sentence or damages. The only relevant consideration here is the likelihood of embarrassment. Another fact paragraph 6, with us is that civil suit often drags on for years, and it is undesirable that civil proceeding should wait till everybody concerned has forgotten all about the crime. The public interest demands that criminal justice should be strict and sure, that the guilty should be punished, while the events are still praised in the public mind, and thus the innocent should be observed as early as is consistent with the fair and impartial trial. Tomorrow, this is the
Yes. Now, next one. This is also similarly manner. Next case is also 2008 5 Supreme Court cases 765. Here also same judgment is follow manner and the timing is same. Then manner 2009 IBSCC 528. Here also will be 3 judgments. It is reiterated earlier.
Yes.
Course file. Paragraph 21, 22, and 24. Now we will finally come to the question part. Well, passing part. I will first take a lawsuit to the decision of there is a single sigma, like a single separate image, not very big.
Sorry,
There is one decision separate image.
separately. No,
Here,
what is given separately, okay.
how about
RP Kapoor,
that?
yes, yes.
There is a famous case lawsuit must know. RP Kapoor versus State of Punjab. The quashing. Yeah, earlier the quashing was only on 2 grounds. That primary case and whether there is any reviews on the process of the court. These were the 2 grounds clear minor in the RP Kapoor case in 1960. But now it has been expanded, having some other considerations in Bhajan Lal case 1992.
Yes,
Bhajan Lal 1990 supplementary 1 SCC page 335. Will also kindly come to directly the grounds on which the proceeding can be quashed. 102. Yes, 102. There are 7 minor considerations.
yes,
In the background of the interest of the various relevant provisions of the code and of the principles of law enhanced by this code in the series of decisions relating to the exercise of the extraordinary power under Article 226 the 482, which we have extracted and reproduced above. We give the following categories of the cases by way of illustration, wherein such power could be exercised either to prevent the abuse of the process of court, any court, or otherwise to secure the ends of justice. Though it may not be possible to lay down any precise, clearly defined, or sufficiently channelized and inflexible guidelines, write a rigid formula, and to give an exhaustive list of myriad kinds of cases where such power could be exercised.
Number one, where the allegations made in the first report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. तुम्हारे FIR does clearly make out a case. So I'm so asking. Number two, where the first ground supports me, where the allegation in the information report and other materials, if any, accompanying the FIR do not disclose a cognizable offense. This also we have got in our support. Justifying an investigation of a police officer under section so of the code. Third, where the uncontroverted allegations made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offense and make out a case against the accused. So here in after investigations are satisfied, not otherwise. In the investigation, there must have matters minor in the case I. Four, where the allegations in the FIR do not constitute a cognizable offense, but constitute only a non-cognizable offense. But no investigation is permitted by police officers.
So you want to say under which category it falls?
First one is 1, 2, 3.
Hmm.
Because
On the 1, 2, 3.
cognizable offense, crime case is shown, taken in the face value.
Hmm.
Also, because a lot of students appear not going to the materials of the evidence part, which is wrong, which is right.
Yes.
No matter that it is not a non-cognizable offense, it is a cognizable offense. So, my case is supported by the law.
Yes.
And 5B, the allegation is so absurd that any court may come to listen that is absurd. There. So, this is yes. So this paragraph 102 is the setting ball manner, which is subsequently also in all decisions, this law is being, though three is the bench manner, it has been.
There is the foundation, basis.
Because RP Kapoor was very limited on only in 2 grounds. Now these are the grounds stated. In the RP Kapoor case, there was no description whether they should be cognizable, non-cognizable, it was not there. Here only 156 part is there. If the FIR is under 156 of the CRPC, then then the officer must be offense must be cognizable. Then only the role of 482 will come per part. So this is my case.
Yes.
So far, the judgment they have cited.
Hmm.
Now, we have the opportunity to go through them. Can I give him a 15 minutes tomorrow or Monday?
Problem. You want to respond to the judgments, Mr. Bora?
I don't want to deprive him from any benefits.
Because he will be admitted, madam. For another day.
6th, let us have it on 6th.
6 is another hearing day.
Hearing day. Every day is a hearing day.
So earlier, my lord, the first part will be finished by 1 o'clock, you lost missing, and from 2 o'clock there was a hearing every day. That most of the lost will
6th is all right with you? Okay.
It is always part of it.
Matter. Learned counsels have been heard. Fixed on 6th for further hearing.
Can it be on 7, madam?
Or 8th, then we can have it on 8th. If 6th is not.
8.
Then further hearing on 8th. 8th of June.
Partner, madam.
It is part, although we don't have to say it.
First order is there, madam.
All
Further
right.
hearing, your lordship.
Yes, further hearing,
Yes.
further hearing.
Item 23.
All right,
All right, sir. Big lord.
WBC plus
Eight minutes, very good. So I think we are stepping in. Stepping in. You can give it.
WBC.
If we get stepping in, I will be. Yes, forest matter,
my lord.
some forest matter.
Yes. Without going to merits, there is an appellate provision against this order.
Passenger, district, passenger,
Yes. So she can,
district judge.
district judge. So, but lordship has to condone the delay. There's a specified limitation. She can avail that remedy.
The vehicle was seized by the respondent authority on in the year 20 lots. And thereafter they have followed the procedure and they issued notice to the owner and the accused lots. And accordingly, the owner appeared and filed all the relevant documents before the respondent authority lots. Thereafter,
No, but why did you not go and file the appeal? You can file an appeal.
I have prepared one application lordship. That is why I have come before your lordship.
Where is the application?
Lordship, I have prepared one application lordship on 5/3/22. Lordship. Annexure 4. Page number 14 lordship. And seeking custody of the vehicle lordship. But the respondent authority has neither passed any order in my matter lord, in this petition lordship. They have thereafter, after 2 months lordship, in the month of May, they have issued the confiscation order and sent it to the petitioner through registered post lordship. They have neither passed any order in my
Forest,
petition
forest,
lordship.
forest. Where is the section appeal? Appeal,
Section
49.
49.
49 has subclosure subsections.
yes. No, 49 is confiscation, then.
49 is confiscation, parent provision.
49.
49.5, my lord, it speaks about the steps,
49C,
C appeal. 49.
but she preferred, my lord, or the petitioner preferred 49A.
49A is,
Note, power to release property seized under section 49. My lord. This has to be exercised,
I have
not the officer below forest ranger.
because before a DFO,
Yes.
then. So this order you pass under 49.4,
49,
49.4.
49.4.
When was this order passed? 2nd May.
order was passed on 4/5.
4/5/2022.
And I have filed a petition on 5/3.
2nd May. Page 19.
Page 19.
Page 19.
Second May, madam.
2nd May. Why do you say 5th of May? 2nd May.
Second.
Now, when did you file this application?
Lordship, I have filed this
5th of March.
5th of March, before the authority, Lordship.
Which authority?
Before the respondent authority, DFO, Lordship. DFO Rongyal.
Hmm.
But they have neither passed any order in my petition, Lordship, and mechanically they have issued this order and sent it to the registered post, Lordship. And after a week, Lordship, I have received the petition order, Lordship. My only prayer is that, Lordship, they should have passed any order in my petition, Lordship, either rejecting or allowing, then I could prefer an appeal before the landed court below, Lordship. But they have passed the order without any.
Yes, what do you say?
This is something what happened, my lord. This is a author's officer with the DFO, my lord. So well, 49A, before 49A, what?
No, not on that. There is an application stated to have been filed by the petitioner.
My lord,
Page 14.
my lord.
According to her, this remained with the authority. They did not pass any order. Instead, they passed the order at page 17, which is 2nd of May.
Well, before that, what had happened? My Consolidation proceeding was initiated, my lord. Consolidation proceeding was initiated by, my lord, in 2020 itself, my lord.
What has happened to this application?
This has, my lord, this, I,
The record was called for.
record is there, my lord. Record is-
This
Find out.
petition may not be in the record, Lordship.
Have you filed this application?
Yes, Lord. And thereafter, I have personally visited the office, Lordship, and then over telephone also I have.
Any receipt to show that you have filed?
Well, what happens, this 49A remained eclipsed because my lord, already in 2021, record, I have the records, my lord, Consolidation proceeding notice were issued, my lord.
Yes, Lordship. Notice was issued, Lordship. And
So, my
accordingly, I
lord,
have
notice-
prepared,
so, my
Lordship.
lord, when Consolidation proceeding is initiated, there is a process, my lord. They have to go for review, my lord, because this power under 49A has to be exercised by a officer not below a rank of. For
It is-
example, not
it is-
above the DFO, my lord. That's why.
It is addressed to the office of the DFO.
Yes, my lord, that is the issue. If my lord reads the provision for once.
Hmm.
My lord, there is a provision provided that whenever such release is made, the officer releasing the property shall immediately make a report to the authorized officer.
Hmm.
But my lord, here the authorized officer is the DFO.
Hmm. Then,
Authorized officer describing the circumstances and reasons for the release. And for the penal part, my lord, any forest officer not below the rank of a forest ranger. Penal part, my lord, not below the rank of a forest ranger. So, my lord, in this case, Confiscation is this officer, authorized officer is the DFO, my lord. How can a DFO? It has to come to forest ranger, my lord. It cannot be direct go went to.
so what stops the DFO from sending it back to the ranger? Simple as that.
That also can be, there's an aspect, my lord.
Why is it so technical?
Notice was issued from the DFO, Lordship.
Yeah.
That is why I have prepared and I have filed petition, Lordship. And accepting is the notice.
There is a provision under 49B.
49 is a review, my lord.
So we'll direct them to
Go to
the authority. and-
conservator.
Huh?
It's a conservator.
All right, conservator will invoke the provisions under 49B.
Yes,
On an application, this is to be treated an application.
my lord.
Or you file a separate specific application
For the conservator.
under 49B.
Yes, my lord. He, in compliance with that, my lord, in reply to the notice issued, my lord, the owner appeared, my lord, and gave his statement, my lord, before the DFO.
You are asking for 49A.
But 49, my lord, only
Release Lordship power to release property. Lordship.
Release what? What do you want to be released?
My vehicle, Lordship.
Vehicle.
Yes.
See that.
And in their order, Lordship, they have not mentioned any regarding my petition, Lordship.
Where is the provision under the Forest Act regarding confiscation of the vehicles?
My lord, 49A, ma'am.
Okay.
Seizure of property.
49?
Seizure of property. Liability. Okay.
49(4), ma'am, 49(4), ma'am. Subject to the provision of subsection 5 and 6, where the authorized officer upon production before him of the property seized upon receipt of property about seizure, as the case may be, and after such personal inspection or verification as he may deem fit and necessary, is satisfied that a forest offense has been committed in respect thereof, he may by order in writing and for reasons to be recorded therein, confiscate the forest produce so seized, together with all tools, vehicles, cattle, trucks, motorized boats, carts, machineries, rafts, vessels, ropes, chains, or any other implements or articles used in committing such offense. In these cases, my lord, maybe my lord, this petitioner has not instructed the council properly, because my lord, in compliance with the notice issued, he had personally appeared and recorded his statement. Way back in, my lord, before this petition was moved, statement was recorded in 2nd of September 2021.
Your remedy is in appeal. You have to go for appeal. Under 49,
Yes.
if the officer is believe that there is any offense committed in respect of forest produce, not only the forest goods,
Yes.
even the vehicles, vessels, everything can be seized. That proceeding they have done under 49. So you have a remedy under 49B, file a review, or go in appeal. 49C.
49C is the appeal.
49C probably will be more efficacious, my lord.
That's for her to decide.
Yes.
That's for her to decide. Yes, madam.
My only grievance is that they have not passed any order in my petition, Lordship. And in their order sheet, Lordship, they have neither mentioned anything about this petition, Lordship.
But you appeared in before the authority.
Yes, Lordship, I
Then-
appeared.
Then this order has been passed. This order has been passed. This order, which is there in page 17, will be deemed to have been passed in your application, although it is not specifically mentioned.
They have not specifically mentioned.
But your application is for release of the vehicle.
Yes, sir.
They have given a detailed finding how the person is involved and what vehicle was there. The seized timber along with the vehicle is confiscated. Page 19.
I shall prefer an appeal, then Lordship kindly made an observation that the delay part may be found.
Where is the limitation here?
Well, 49C, it's 30 days.
30 days.
49C.
49C, my lord. Any person aggrieved by an order under section 49(4), section 49B may, within 30 days from the date of communication to him of such order, refer an appeal to the district judge having jurisdiction over the area in which the.
When did you receive it?
My lord,
When did you receive this order?
Lordship, the order was passed on 4/5 and I have received the order after a week, Lordship. They have changed the order to registered court lordship.
Our learned counsels for the parties. This criminal petition is filed by the petitioner, praying for quashing of the order dated 4/5/2022. Whereby, along with the forest producers, within bracket, Hollock Sawn Timber, HOLLHALLOK, Hollock Sawn, SAW, Sawn Timber, along with the vessel or the vehicle bearing registration number UP 21 capital CN 6191, which is involved in OR number PS 13 of 2021, dated 11/9/2021, and it's confiscated to the state of Assam. Full stop. Learned counsel for the petitioner submits that the petitioner is not at all involved in any of the forest office offenses. Rather, he was carrying a consignment of blankets from Ludhiana to Guwahati. However, after unloading the goods in Guwahati, while returning from Guwahati, the vehicle was loaded with sawn timber without the knowledge of the owner of the vehicle. Also, it is submitted that all the offenses, if any, committed by the driver, the owner should not be penalized and the vehicle ought not to have been confiscated. Also, it is submitted that the vehicle is lying in the open premises of the respondent number 2 and without proper lack of care, without proper care and parking, the vehicle will vehicle will be damaged. Also, learned counsel for the petitioner submits that by an application dated 5/3/2022, filed by the petitioner, praying for release of the vehicle. Prayed for release of the vehicle. So, before the competent authority. So, the petitioner also approached the competent authority and made oral prayers for release of the vehicle. However, without considering the prayers made by way of the application dated so and so, the petitioner the respondent number 2 by the impugned order dated 4/5/2022 confiscated the vehicle along with the timber. Post of being agreed, the present petition has been filed. Where a learned counsel appearing for the Forest Department submits that there is no infirmity in the order passed. However, there is an alternative, a provision for alternative remedy prescribed under the statute available to the petitioner, which can be resorted to by the petitioner. Also, learned counsel for the Forest Department is referred to Section 49C of the Forest Regulation Act 1891 to submit that there is a provision for appeal to be preferred. However, preferred against any order passed under Section 49(4). Also, it is submitted that the impugned order is an order passed under Section 49(4). Therefore, the appeal ought to have been preferred. Also, however, there is a limitation of 30 days within which the appeal ought to have been preferred. Also, there are learned counsels for the parties have been heard, pleadings on the record have been perused. It is seen that by the impugned order dated 4/5/2022, the competent authority, the respondent number 2, DFO is respondent 2, has passed the following order. Has passed an order confiscating the vehicle. The relevant portion is extracted below page 18 and 19, findings and order. Also, there are perusal of the Forest Regulation Act 1891 reveals that there is a provision for an appeal under Section 49C. Also, there is also a provision for review under Section 49(B). Also, the sections 49B and 49C reads as under. Is extract 49B and 49C. Where having heard the learned counsels for the parties and upon careful perusal of the provisions of the Act as well as the pleadings on record, this court is of the view that the proceedings initiated under Section 49, the provisions of Section 49 lay down a prescribed procedure for seizure of property liable to confiscation. Also, from the impugned order, it is apparent that the petitioner appeared before the competent authority and an opportunity of hearing was also given to the driver, of the owner and driver. Who appeared? Owner or the driver?
Both appeared.
And both the owner and the driver appeared before the authority. Upon hearing the entire matter, the competent authority had passed the order impugning the present proceedings, confiscating the vehicle. Under Section 49(B), capital B, there is a provision for review which can be
Sorry,
initiated.
madam, the driver didn't explain. Driver was
Only owner appeared. Under Section 49 capital B, there is a provision for review and which may be initiated suo motu by the forest officials or on an application by the aggrieved party to call for and examine the records or any other order under Section 49(4) and to make such inquiry and cause such inquiry to be made and pass such order as deemed fit. So under Section 49C, there is a provision for filing an appeal to the district judge having jurisdiction over the area in which the property has been seized. The district judge, upon giving a reasonable opportunity of hearing the parties, shall pass such orders as deemed appropriate. And such orders of the court so passed shall be final. Full stop. An appeal under section 49C is required to be preferred under within a period of 30 days from the date of communication of such order by the forest officials. Full stop. Where a learned counsel for the petitioner submits that the order dated 4/5/2022 was received by the petitioner through post,
Yes, tourist.
through registered post after about a week. Full stop. Thereafter, the criminal petition was filed under section 21 was filed on 21st of May 2022. Full stop. Learned counsel for the petitioner submits that the order impugned in this criminal petition is the order passed by the competent authority, forest authority, which is impugned in the criminal petition, has been impugned in the criminal petition because the application preferred by the petitioner seeking release of the truck remain pending and no orders have been passed. Also, it is the submission of the learned counsel to the petitioner that till date, no specific orders have been passed on the application preferred before the DFO, North Kamrup Division, Rongia, seeking release of the vehicle belonging to the petitioner. Full stop. Upon a careful perusal of the impugned order dated 4/5/2022 passed by the DFO, as well as the application stated to have been referred by the petitioner before the DFO, it is seen that the forest officials had issued notice to the owner and the driver, and the owner, namely the petitioner, had appeared before the forest officials, and an opportunity of hearing was granted to the owner, and thereafter a detailed order has been passed whereby the vehicle was confiscated along with the seized timber. Full stop. The impugned order, although no specific order has been passed on the application stated to have been filed by the petitioner, the prayer made in the impugned order has been addressed in the prayer made in the application filed by the petitioner has been addressed, has been dealt with by the forest officials in the impugned order dated 4/5/2022. Also, by the said order, as discussed above, the vehicle of the petitioner has been confiscated. Also, upon giving my considering the matter in its entirety, this court is of the view that since there is a statutory remedy prescribed under so and so regulation in the form of section 49C, in the form of an appeal under section 49C, ends of justice will suffice if the petitioner is relegated to file the departmental appeal under section 49C. Full stop. The delay, the period of 30 days prescribed can be condoned in view of the fact that within 30 days of passing the impugned order, that is 4/5/2022, the petitioner had approached his court by filing the instant criminal petition, which was filed on 21 May 2022. So under such circumstances, the criminal petition is disposed of, enabling the petitioner to approach the departmental authorities as prescribed under section 49C and prefer an appeal. Full stop. If the appeal as prescribed under the Act is so preferred within a period of 30 days from today, the appellate authority will consider the appeal so preferred and dispose it on merit. Criminal petition stands disposed of. Mr. B. Sharma appears for respondent number 1. Mr. D. Gugoi for Forest.
Yes.
24.
Yes, Mr. Dega. Who's appearing for respondents? This is again.
Again, this similar trial court judgment. If there's another criminal revision has been filed with a respondent. The package is being numbered as criminal revision petition 610.
You want both to be connected.
Should be connected.
It is submitted by Mr. N. Dr. N. Deka, legal counsel to the petition that that criminal petition number
610.
610 of
20.
22. Criminal revision or criminal petition?
Criminal revision.
Criminal revision petition 610 of 2022 has been filed by the respondent against the impugned order passed by session judge. Impugned order is order dated 26/9.
Correct.
By the respondent hearing. Therefore, it is submitted that both the criminal petitions be listed together. So, Mr. B. Sharma appears for the state of Assam, respondent number 1. None appears for respondents 2, 3, 4, and 5. Although office note reflects that they are represented by counsel. Accordingly, let both the petitions be listed together again.
Let me be fixed note. 22nd or 27th of this month.
57, let it be in July. July.
28th of July, 20.
20, 20th of July, 20.
25.
Senior.
Hmm?
My senior, I'm
Who is your senior?
Mr. Dear.
The request of MS. Your name? MS T. Goswami, matter stands adjourned. As it is submitted that the arguing counsel, Mr. D. Gogoi is indisposed. Mr. Jiuddin appears for the respondent.
Number two.
2, Mr. B. Sharma for respondent 1. List in August, 1st of August.
26.
This is a case number where child custody has been granted during the stage of investigation by order which is without jurisdiction.
Where is the order?
The order is order.
9-6.
Yes,
9-6.
9-6. But prior to the on 7-6, another order was passed with asking that the DNA test should be of the baby should be conducted. That is at page 27. And my lord, thereafter, the samples of the baby was taken, my lord. The samples of the complainants were taken, my lord, but the samples of the parents with the baby is that one, those were not taken. The allegation, my lord, is that on the at the time of the birth, my lord, the baby of the complainant was given to the petitioners in the hospital, and the complainant was told that a dead child was born to them. So those circumstances, this.
Who are you? Who are you? Who are you?
I am the parent of the child.
This is your status report was not called.
Huh?
Ask okay.
Status report.
You also have to kindly see the order.
Yes, sir.
Status report.
The issue is whether
That's something already something under 363.
that's a different issue. Whether
Oh, no.
whether the order could have been passed by the learned court, put into the jurisdiction matter. Because it's a family, chief judicial magistrate doesn't have the jurisdiction to pass an order. That is the state of investigation matter. And this right is only reserved to the family court matter. It's very clear, there is a clear bar on the family court side. A custody of a child cannot be, it's not a chattel matter, it's not a commodity matter that it can be granted just like that matter.
But the matter is pending before that court.
No, that is without jurisdiction. That's the point we are trying to make. The order has been passed by a court, which is the jurisdiction will pass in one matter. Lordship will kindly take a look at the section below.
Wait, let us understand the facts. You claim to be the parent.
Yes, madam.
Father.
Yes, madam.
And who is your wife?
Father and mother, madam.
Father and mother.
Parent, madam. Well, what happened was the
Who
complaint was a complaint.
is Sohidul Ali?
Sohidul Ali is the father, madam. Father.
You are representing him.
Yeah, it is.
Then
Then what happened?
number 2 and 3,
Madam,
respondents 2 and 3,
2 and 3, madam, are the complainants who are claiming the child, madam, to be theirs.
and custody has now been given
To
to.
them, madam.
So what is the report of the DNA profiling?
DNA is very interesting, madam. It says it tells you the mother of the child, it doesn't tell you the father. And our DNA test was not taken, madam. You will not, it ought to have told you both, madam. That also the learned court has recorded, madam.
But if the profiling, if your profiling is a husband tallies,
Madam.
then you are in deep trouble.
Madam. No, madam. What has happened, madam, our profiling was not done at all.
The profile of the child along with the respondent number 2,
Madam.
there is no dispute. You are not
No, no,
questioning
we
it.
have, no, that's a part of the investigation. We have
No, but that's the finding. That's the
We
finding.
are not on conditional marriage, and DNA test is also.
So
not-
in that perspective, if your profiling
Madam,
tallies with the child,
madam.
then you are in deep trouble.
But madam, but since our profile was not done at all.
So that's what I'm trying to tell you. And it's something to very eagerly to look forward to. You could be in deep trouble.
No, that should not be the case here, madam. Possibility is there, madam. That should be the case here. No, madam. Madam, totally different backgrounds, madam. That's not possible, madam. That's not there. Then the here, our basic case is the investigation is going on. A DNA test was directly conducted. Then it opted being allowed to both the parties. That was also not done. And he passes an order giving the interim custody. Custody can only be granted by family. And my learned senior friend is trying to say that it's an interim custody. The court which cannot have the jurisdiction, it cannot pass an interim order rules. That principle will be applicable. But 9-6 order, will find that this court is also recorded. It's the mother's DNA which is telling, but the father's is not telling.
No, but custody is given to the mother.
Father and mother, the claimants will complainants, 2 and 3 men. They are the
No, custody is given to the mother.
mother.
Petitioner, who's the petitioner there?
Petitioner is the no, they
Filed by the mother,
complained by Nazma Khan.
mother.
Yes, mother.
This is not custody as understood in family court matter. This is custody is in terms of the term used called Zimma. Now, who is supposed to look after the child?
This is very dangerous because this child was all along since his birth, was with this parents. Petitioner. Suddenly, a 3.5-year-old child has been handed over to someone else. That's what I'm saying. It's not a commodity, man. It's much more serious like that. A baby has been suddenly snatched away from the parents whom he used.
Yes, Mr. Kotoki, what do you say?
First of all, you will also take up the FIR. FIR will clear it.
No, regarding the specific objection.
We have stated that.
No, regarding the specific objection that this court does not have the jurisdiction.
The question of jurisdiction, if it is a husband and wife, the child the question of jurisdiction will come, but it's not like a husband and wife. It's a matter relating to the particular facts of the case that there was an exchange of babies. Because our case is that our baby was exchanged. That is the basic allegation they have there. If the INA number has been exchanged, that if your lordship take up the FIR, clearly your lordship will find, because we have filed the FIR on 29/8/2018. If your lordship take my FIR, my lord, that is page 16 of the revision petition. That will clear my lord. What is the fact of the case? Brief informant case is the informant wife Nazma Khatun admitted on 3/5/19 at FMSC hospital, Barpeta for delivery. On 5/5/19 at about 1:50 when she gave birth to a male child. Cesarean. And since the child was facing breathing problem, as per advice of doctor, child was admitted to NSC and evening form number 317 inborn was written. At the time, the evening at 6 PM, one Nazma, the wife's name is same, Nazma, same, but the husband name is different. Both the babies, mother's name was same. Son of Sohil Krishna, of Gosaigaon, admitted as a newborn baby, born on 2-3 days ago at village Gosaigaon, NSU, whose IRN number was 309, out of bonds written. After admission of newborn baby of the informant's wife in NSU, the informant and his relative wanted a provisional to the doctor did not permit it. They could not meet the baby. On the next day, on 6/5/2019, about 11th day, the NSCU authority, all the informant were phone, told the newborn baby of the informant was expired, and the body of newborn body was handed over to the informant. Informant told the dead body is not that child. Informant told the child was informed by gave birth to a 2 kg child, the dead child is 2 kg weight. NSU authority did not give importance when informant asked for him to take the child. Health condition of the informant's wife was deteriorated. She was admitted to ICU, and so it is delayed in collecting the document. Cause of death is given in the informant by NSU authority was misfiled during the treatment of mental file. Informant applied for duplicate cause of death of certificate. When informant came to bring the duplicate cause of death certificate, then during the time of writing the certificate, informant saw that IRN 413 was written in the file and outbound on the form. He informed the person who was writing the certificate that informant child is IRN 310 and inborn was written. And he bring the same file and informed that he was giving to Nazma, wife of Sohil. The child is still alive. Originally our number is IRR 310, it was inborn. Then the child was there.
Matter is pending before which courts? CJM.
CJM.
charge sheet file.
So are they like the kidnapping case, man?
These are matters of marriage matter.
No.
Marriage matter, the trial will take its own course.
The child was kidnapped. There is a priority case come to the.
Rest of the.
Now, in an allegation, in a case where there is an allegation of the child being kidnapped,
Matter.
to whose custody do you think it should be given?
So the allegation of kidnapping has to do with because what happened.
No,
here
no, in the
is-
meantime,
Meantime, the parents were existing parents, because my lord, they were, the child was with them for the entire life, my lord. Whatever his lifespan is, my lord, 3 years or half years or 4 years, my lord. From the day one, my lord, he has been recognizing them as their parents, my lord. My lord, this is a very dangerous trend, my lord, because this is the effect of psychology of the child, my lord. Once, my lord, this help, my lord, that finally, whatever the result comes, that's another issue. But if the final decision is taken, my lord, how can the ministry, my lord, because lordship was, let's say, it's kind of custody, my lord, trying to distinguish between the custody, my lord. What section 7 says, my lord, of the family court side, my lord.
family court.
Yes, my lord. Section 7, my lord, G, my lord. That's the most relevant part.
Section,
7G.
yes.
A suit or proceeding in relation to the guardianship of a person or the custody of or access to any minor. So it even says that even access has to be decided in the family court. It's not just about custody, not about guardianship alone. It's much bigger than that. The scope is much larger. A suit or proceeding in relation to the guardianship of the person or the custody of or access to any minor. And this jurisdiction is conferred on the family court. Well, then section 8 exclusive jurisdiction pending proceedings. If a family court is established, my lord, no district court,
Excessive, that is excessive because of visiting rights.
whatever, my lord, visiting, my lord, access, my lord, access is, my lord, visiting, my lord, is saying, visiting right, my lord, that's evidence, my lord, in a very smaller context. Here, what has been given is the custody, my lord, or my lord, whatever lordship may call, my lord, the jimma of the child to that person, my lord. It's even bigger than, my lord, just, my lord, visiting right. The baby has been totally secluded from the original parents, my lord, with whom he was residing. Because they are.
How old is the baby?
My lord, now it will be around about, I think, from 3-year-old that will die.
How it is 6 years. It was password 8/17/76/2000.
Born on 19, so my lord, not 6 years, man. It is born in 2019. 3 years now. Around 4 years, my lord. 23, my lord. 4 years, some days, my lord. We are in the month of June.
Now, you also see that conduct of the petition, one thing. Your courts will find on 8/10/2020, my lord. The IO filed an application to collect the birth circle of the DNA. They did not oppose.
No, how
Your
can
lordship, can you see?
how can they oppose, my
How-
lord? There's a court order, my lord.
They can challenge it, my lord. Nobody is preventing them for.
We have before now, we have before lordship.
They have to come the term. Your lordship, can you? Order sheet, my lord. 8/10/2020, my lord. So you have put on the basis of the prayer made by the IO.
But this application was filed by the IO.
IO, not my name.
So why was it filed by the IO?
IO because he want to, because when he has come to, most probably case that I don't know what is there. Most probably from the case that.
How does he know it's a legal guardian? It is one thing to say that the child, the mother and the child having the same DNA, maybe the mother and the child. But how can you say it's a legal guardian without there being any finding? How can the IO say that this is a legal guardian? The matter is pending before the court for their purpose.
They have collected.
The child was in the custody of the petitioners
Petition, I understand, madam.
for 3 years.
But they did not oppose.
Where is the procedure of opposing, my lord? You say the state of investigation, my lord. Can I say opposing investigation, my lord?
Because
It was on a trial going on that point in time, my lord. It was even charge sheet has only been recently submitted, my lord. It was an investigation going on, my lord, where the IO will find the application for the custody of, my lord, for collection of DNA samples, etc. Where was, my lord, my scope of opposing there, my lord?
There should be a proper trial only then, because I have a party, they were in a post matter. During the stage of investigation, it was only fact finding mission matter. And during that fact finding mission, this custody has been given. That's what I'm agreeing with.
Who was the child with for last 3 years?
That's my.
You have any documents to suggest?
Well,
Because-
the birth certificate said the baby was.
No, the identity of the child is at now. Because our case is the child was exchanged.
No, this
Birth
matter,
certificate
this matter is on the basis of what? An FIR.
FIR, and that was investigation.
Where is the FIR?
FIR, you also find it page.
Page 16.
16. This was filed by whom?
Abdul Muttalib.
By the husband of the lady who has now been given the custody,
Yes, sir.
Mr. Kotogi's client.
Yes. So the
This was in 2019.
It was filed on 28, 2019. Thereafter, my lord,
FIR was filed after 4 months. FIR was filed after 4 months. The child was born on 4/5/19. The FIR was filed on the 29/8/2019.
then in 2008, 10, 2020, my lord, the IO go to the CBI bank.
In fact, I'm told they complete the funeral of the child, which was given, which was their matter, and thereafter they are claiming this baby matter of the petitioner. This is to be decided in the trial matter, first of all. And secondly, again, here also the trial court also cannot give the custody. Trial court only will punish them for kidnapping matter if it is found to be proved. The custody part, they have to go to the family court and get it, the custody child matter. There is exclusive jurisdiction family court. And this is an order which has been passed not the trial stage. This has been passed at the investigation stage, where they were collecting information before the charge sheet was submitted. This is totally below the gross misappreciation of the provisions of law. Court below that. On an application filed by the IML, first DNA test was DNA test is supposed to be invading in the privacy. The child should be subjected to incisions and all. That is also not permissible. But that has been done, rightly wrongly, that has been done.
Now, this is the interim order, my lord. So let them file a proper application before the court, let them submit, because they never joined the investigation.
There is a question, my lord.
Because that they give DNA sampling, man.
Order without jurisdiction, how can it be sustained, my lord?
Where is the application for IO?
I was thinking, you have to find it. First application is on 8/10/2020, my lord. There's an extra page 21.
Is the charge sheet available?
No, it's that is recently identified.
The tendency of the charge sheet is nothing. Charge sheet is only the trial, start of the trial. Questions are framed.
There is true, the style is stolen away. Naturally,
But you know how many charge sheets get convictions, man. Charge sheet is nothing, man. Question here is, could the custody of the child be given at the stage by the family court, the CGM, CGM. When the act specifically burns such a certain course of action.
because on 8/10/2020, madam, the Lanet Division message passed out. Where direction was issued for taking the blood sample of the baby. They did not oppose.
I'm repeating, I can.
No, how is it relevant that they have not opposed?
But at least they, how can it, if the question of act of privacy is there, at least they said they could not have.
No, it's not a question of privacy. This is a question of a dispute as to who are the parents of the child, or to whom does the child belong to. In the proceedings, they have participated. They have participated.
Your Lordship, can I see the order is 8/10/2020? Please, please.
Can I oppose the investigation?
Not,
Do I have the right manner? I do not have that. It's a police case.
Sorry, page number
page number 26.
26. What is this?
page 26. What a revision. See, I put on the basis of prayer made by so and so. When you submitted that on 5/5, the wife of the informant gave part to him for so and so, but 6/5/11 came and see what stuff handed over the dead body of the baby. Subsequently, informant came to the baby was handed over with one couple named Saidul Islam and Nazmo Khatun of Hossain. After taking money. According to the informant, the baby is still alive, living with the said couple. Therefore, to ascertain the actual biological parent, IO has paid for conducting a DNA test of the baby, along with the complaint informant, namely, along with the complaint itself after 2022.
Where are the applications of the IO?
Application is then after 2 years, that is on 2020, 8/10/2020.
Lordship, page 24. The IO, SI submits an application to hand over the child with legal guardian. That is the prayer.
Page 24.
Page 24.
How only on this application order can be passed? There must be a proper hearing.
Yeah, I understand. So let them let them also file an application because it's an interim.
So raise the question of remand back, madam. When the jurisdiction is not there.
When it is an interim order passed by the court.
Interim order, final order of the court, which can pass a final order.
Let them- Whether actually, because the subject matter of the case is that it was, there was an exchange of baby.
That has to be proved personally. It's all in terms of summation and conjectures, madam, at the same time. Nothing more than that. Suddenly, my child may not was with the
So there
parents.
was a manipulation in the
Snatch
certificate also, man, that we had, in the certificate also, there was a manipulation that we have stated in our FIR. But we don't know what is the, what has been collected in the plate of investigation.
They lodged an FIR after 4 months, so they remember that the time.
Why don't you file an application for recalling of this order?
I'm asked this. I'm before the lordship because the order, it's been a jurisdiction, it's a, I'm before the lordship. Criminal courts cannot recall the order. That is interim order. My case is that if the court doesn't have the jurisdiction, it cannot pass any order whatsoever. And lordship will see at what stage this order was passed.
And view of the reason then Supreme Court filed now on High Court file. 451 also why, because after filing of the charge sheet, court has also released officially.
That is a totally different issue, my lord. Yeah.
Court can pass.
The specific court is given assigned that you are the authority to decide whether the access, custody, guardianship, everything is for child.
All right, we'll carry on the hearing.
Right.
You come up with show us the judgments, if you have any. We'll have to hear this matter. Tell us a date, sometime next week we'll hear it. And I think we should call for the scan copy of the case records.
I think it was only for
I don't think the entire record is here, only the status report is
The
there.
same report was closed.
Status report is there. Hard learned counsels for the parties. By earlier order dated 18/5/2023, status report was called for. From the court of CJM Borpeta in connection to PRC 1242 of 2023. Full stop. The court has, the status report has called for, is available, and it is stated therein that charge sheet number 1272 dated 31/12/2022 has been submitted, and cognizance was taken on 26/4/2023 against the accused persons under section 120B 363 IPC in the matters fixed on 11/7/2023 for appearance. Learned counsel for the petitioner submits that the court of CJM does not have the power to give any orders, pass any orders regarding custody of a child. It is specifically barred under the Family Courts Act, 1984. Also, learned counsel for the respondent, Mr. Kotoki, on the other hand, submits that this is only temporary order. This which has been passed in view of the DNA reports showing the child, showing that the DNA of the child and the respondent number 3 is the DNA profiling is similar, is same. And therefore, interim custody has been granted to the respondent number 3, and there is no infirmity in the same.
Actually, what is matching is important, not same matches with the DNA profile.
The DNA profiling of the child and respondent 3 matches. Therefore, the court passes the order. Also, let the scan copy of the entire case reports be called for from the court of CJM in connection, CJM Borpeta in connection with so and so, PRC case number so and so. Along with case diary, and the matter be legible copies of the case diary and the LCR we call for, and the matter be listed thereafter. List again on.
And the
8th, 15th. 15th.
16.
Let it be on 20.
Some other matters speak.
Then 22nd.
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 If the complainant understands that part of the DNA report, things should be not enough. It could be another turn.
So they give their risk. Possibilities are there.
List again.
Item 27.
Yes, Mr. Agarwal.
Passing of the complaint. But the dispute is in between the family members.
You are for the petitioner.
I am for the petitioner. Right. Was better than that.
And who's for the respondent?
Respondent will not he is appearing in person. For I have been told was last few occasions he is not appearing in court. Petitioner number 2, right? Petitioner 2, petitioner number 2, right? That fact has been already taken note of by his honorable. Now we are left with 1 and 3. And the respondent number 2 is the brother of the petitioner number 1.
So there is some interim order.
Interim order is there. That interim order should not.
So the matter should be listed for hearing.
Yes, those for hearing. In fact, on the last occasion, it was in the hearing list.
It's listed for stay matters today. Listed for stay matters.
Listed for stay matters. Interim order by the
Mr. K. Agarwal, Learned Senior Counsel, submits that the matter be taken up for hearing. It is submitted that petitioner in person,
respondent number 2.
respondent number 2 appears as a petitioner in person. Is he a lawyer?
Is a lawyer. At one point of time,
There was an order directing
and we can still.
Micah Street, but that is recall. That is recall. That
So
is
he
required.
said that he will attend perspective, so.
However, when the matter is called up today, the respondent number 2 is not present before the court. Accordingly, let the matter be listed for hearing. In the week beginning from 19th
Can it be on other.
August,
That
third-
from 7th on.
7th or 8th of August. 8th of August. Mr. B. Sharma for the state.
They are formal party, it's a complaint case. So the interim order will.
Interim order passed earlier will continue. Matter be listed for hearing.
28.
None appears for the petitioner on call. Mr. D. Sharma for this appears for the state. List after 2 weeks.
30.
Yes,
On the last topic, interim order is passed, and then the stay.
you are appearing for respondent 2.
Lordship. Lordship, we will file a Okalam on 29th. Lordship, the matter may kindly, we will be kindly allowed to file an exhibit. In opposition. There are certain texts.
Mr. S. Mitra appears for the petitioner. Mr.
He does not.
P. Das appears for the respondent number 2, who craves leave. Seeks permission to file objections.
Lordship.
Prayer is allowed. List the matter
The fields, Lord. So we have to obtain certain instructions.
in the month of August. The month of August. Interim order passed earlier will continue. List according. This is a 23 matter. So there'll be other
Okay.
old matters being given precedence.
Interim order.
Interim order will continue, yes.
Time item 8.
I think we should release this matter from part R because I am taking up criminal matters now. Mr. Who's appearing here? Respondents. Yeah, anything to submit?
Lordship, only your last petition, Lordship. Instructions is for your Lordship. As to, because we have stated in our academic position, your Lordship, that the respondent number 5 was in the court position.
So 1, 2, and 3 did not, someone died, someone did not appear, something happened. And then private respondent was serial number 4 and she was appointed.
They are directed to open instruction that why the serial number 4 candidate was appointed as a principal. Answer is the page number 46. But if I dispose it also, as the entire, as I have gone to the order, the entire thing is that it is just one instruction. And if you guys will explain the page number 46.
46.
46 of the affidavit.
46 of their affidavit. Yes.
In the panel list, it is seen that Srimati Bharati Bhattacharya
No.
position.
1 minute. 46 of their affidavit.
That is a running page number of the.
You are referring to running page number.
Yes.
Running page number is showing something else.
Annexure 1 of the.
Running page number shows a letter to the principal by the inspector of school. 8/8/2006.
Annexure located under the annexure 1 of the affidavit number.
Annexure 1. Filed by respondent 3.
Respondent.
Yes.
The second,
Yes. 46. Yes.
the printed page number.
Running page is 87. Yes.
In the panel list, it is seen that Srimati Bharati Bhattacharya is in fourth position. Srimati Bharati Bhattacharya is a specially able person, within bracket physically disabled person, and as such she is entitled to the specific benefits as provided under the Right of Person with Disability Act 2016. So this is their explanation. And my submission is that this advertisement was issued in the 2016, and then it was issued as per the 2003 rule. But at that time, there was no provision of.
No, it was, when it was advertised, this Disability Act, was it in place?
No.
It was not brought into.
It is came into force only in the 2017 when the August Memorandum was issued.
But at this stage, as on today, the Disability Act is there.
Yes. And Disability Act is there, Lordship, and even then, Lordship, for a moment, I am assuming that this paragraph 3 lines is correct, and also it is liable to be set aside, but the Disability Amended Rule 18, which contains the disability clause, it says that the total number of posts has to be identified before selecting any person under the scheme of reservation. And it is a horizontal reservation that anybody can participate in the selection process. And in person, this appointment is given in person to the advertisement dated 2016.
You also fall into that category,
No,
disability.
disability category, because the advertisement is issued in the general category. And both the person, both the petitioner and the private respondent participated as a general candidate. And nowhere throughout the litigation process, nowhere he claimed to be appointed as a disabled candidate in pursuance to the advertisement dated 2016. There is a series of petition filed by the private respondent. And nowhere the observation also given by this court that he has to be appointed as a disabled candidate in pursuance to the advertisement dated 2016. Because that advertisement itself, it was issued at the time when there was no provision of Disability Act to appoint someone under the scheme of reservation. That is why there is a series of litigation. It tells the provision, it did not tell in the advertisement.
So therefore, the writ petition which was filed was disposed, giving liberty to come back to the court to challenge in case there is any deficiency in the new act.
Yes.
So under the new act, there is a provision.
Yes.
My question is, even under the old act, old rules, if there was no provision.
And there is a provision.
On the, when was the order passed for our appointment?
27th October 2021. 27th October 2021. Lordship, for a moment, Lordship, I peruse the page number 34 of my writ petition.
The earlier rules, the selection was made on the basis of what district?
On the basis of the current free rules, Your Honor.
Was it on, it is not school wise,
Not school wise, Your Honor.
it is what district wise.
District.
Now?
Now also it is your Lordship district wide.
There is a change. Education. Earlier it is 2003.
Free rules, Your Honor.
Lordship, one important point is that the first round of litigation came to end in 2021. As the petitioner's counsel submitted, the matter has become impersonal. And when the 2018 rule came, again she filed a writ petition highlighting her grievance that The reservation clause contained in the 2018 rule, it is about the 1995 Act, which is already repealed. That was hard given. So it was not at all connected with the appointment in pursuance to the advertisement dated 2016.
Vice principal is school wise.
Principal is school wise, not with 13-year-old.
Okay, now what is your prayer?
My prayer is that our appointment shall go. And
How does it benefit you?
if they, because I was holding the charge of vice principal. I have been,
Your prayer to set aside her appointment.
they may go for the press advertisement.
They may go, but until they do, there will be somebody required to look after the affairs of the school.
Not it is
So-
to appoint him as in charge. principal.
So that in charge thing may not work for you.
That will be decided by the authority because I am the senior most teacher and as per the rule, the senior most teacher is being appointed as a vice principal.
Who's for the respondent? Who's for the respondent?
Respondent.
And Lordship, one thing is that this amended rule 18, the person cannot be appointed under the scheme of reservation in pursuance to the advertisement dated 2016. And they have appointed the private respondent in pursuance to the advertisement of 2016 under the scheme of reservation. And this scheme of reservation candidly says that the
You can't, yeah. No? You don't get a
Okay, the
vote. I think it's right.
post has to be identified.
What is this?
The the interview,
It is in the part, it is a part of the record.
not the statement of interview, your lordship.
What is the name? Where is the name of the petitioner?
It's serial number 1, your lordship. Respondent number 5, serial number 1.
Serial number 1 is the respondent 5.
Respondent 5, your lordship. Because the first position is at serial number 10. He was,
And petitioner is not there.
lordship petitioner is in serial number 3, your lordship.
3.
The marks scored by him is 8, your lordship. Total mark 8. And the marks scored by respondent number 5 is 8.5.
So the person who scored highest is at 10.
10, your lordship. But because he was appointed in some other school,
He went
not
away.
joined, then second
Second,
position
retired.
retired. And the third position, he showed his unwillingness. We did not.
No, that is true, Lordship. That part is admitted. That my friend is highlighting that the lead petitioner, that the lead petitioner came in the court was.
Okay, who's for the respondent now? Private respondent, who's there?
Lordship, somebody had appeared, Your Lordship. We
Well, understood in that, Lordship. If the three selected persons whose name were enrolled in the panel, if they do not come forward to join as a principal, someone shall not be appointed as a principal from the waiting list because there is no provision in the rule. In both the count laws, our appointment shall go. As the rule.
Let us have it on Monday, Tuesday. You remind us, make a mention on Tuesday.
Lordship.
We'll- You make a mention, we'll see, we'll take it up, list on 8th. List on, sorry, 6th. As the learned counsel for the private respondent is not present. MS so and so learned counsel, you are appearing for education,
and secondary education.
secondary education department. And Mr. Mazumdar appears for the petitioner. What instructions were you required to furnish?
Lordship, how respond number 5 was in the fourth position, Your Lordship.
No.
That is what.
As the private respondent was placed in the fourth position, why she is appointed as a principal? That order reflects that is the answer.
In pursuance to the directions of this court, dated 16/5/2023, learned standing counsel for the department has produced a copy, extract of the records to show that the private respondent was appointed as a principal in view of the fact that the first, second, and third, in view of the fact that the candidates who secured the first, second, and third position in the serial were not available for being appointed, and the next available person in terms of marks is the private respondent
Number 5.
5, who scored a total of 8.5. And it is under such circumstances that the private respondent has been appointed.